Your Honor, one real quick thing. So
Okay.
it comes up with
As far as like,
We're on the record.
okay. Obviously, we had previously objected to introducing evidence related to the alleged attempt running over Detective Hatch, and that was overruled. And it's come out now through Officer Vaccaro's testimony. We want to have an instruction to the jury that Mr. Valerio was charged in the prior trial with attempt murder on Detective Hatch, and that jury acquitted him of that charge. And that's something that we want brought in, and we're going to ask.
Oh, so you're going to want to ask him if...
Right, and that's why we're bringing it out now.
Oh, okay.
I don't have objection to asking Detective Vaccaro, was he charged with attempt murder with use on Detective Hatch, or did that jury acquit him?
You don't have a problem?
I don't have a problem with
I'm good with that. All right.
I don't know, we need to support that.
We don't. Well,
I didn't even know the answer to that.
Oh,
So,
You should have to know the answer of the
I
file.
didn't research his history like that.
Hey,
well, anyway, you can ask the question. All
I'll ask
right.
you, you can say you don't know.
we do now.
Now. Watch me say he was acquitted.
What?
I'll say.
All right. You can ask him the question. All right, let's bring him in.
All right.
Stand on out there.
All right, you're in.
All right, let the record reflect the presence of the attorneys for both sides, the presence of the defendant, the parties stipulating the presence of the jury panel.
Yes, Your Honor. Yes, Your Honor.
All right. Thank you, ladies and gentlemen, for getting back in order. Really do appreciate it. We will get started again. Counsel, go ahead with your questions.
Thank you. Detective, I want to go back and address a couple of issues I sort of skipped over during the course of my questioning of you. And I want to go back to October 4th, 1986. You're in the jail and you're looking at the wounds to Mr. Valerio. Do you recall those questions being asked again?
Yes,
During the course of the time that you're there with Mr. Valerio, does he make other statements to you relevant to the case?
yes.
And can you tell us what that is?
Yes, while I was examining the wound on the back of Mr. Valerio's neck and that damage on his left side, he just said to me, what would you do? Some guy yells at you, you're under arrest, put your hands up, freeze. I didn't know what was going on, I just took off, said something to that effect. And he just said that to me, and so I made a point of remembering that and making it part of the case notes in an officer's report.
So you drafted your own officer's report in this case about your personal behavior or interactions in the course of the investigation, as well as reviewed the reports written by all the other police officers and investigators involved in the case.
Yes,
Now, you may not have known this until recently, but were you aware at some point in time that Mr. Valerio was charged with the attempted murder of Detective Hatch?
yes,
And ultimately, the jury that found him guilty of this first-degree murder, they acquitted him of that charge. Is that correct?
that's true.
Now, during the course of your review of the file, did you have an opportunity to review and see the autopsy report that was created by Dr. Nina Hollander during the course of the autopsy of the victim in this case?
Yes,
Judge, I have in my hand what's been marked as State's Proposed Exhibit number 57. Having previously given that to counsel, I would offer it at this time.
That's the
Autopsy report.
autopsy report. Any objection besides those previously stated?
We have no additional objections to other than those we previously.
All right. And what was the number again, Mr. Chuck?
That would be 57.
57 will be admitted.
Now, Detective, I want to go back sort of to a compilation of looking at the autopsy photos, reviewing the autopsy report, and looking at the crime scene photos. And for the purposes of my question, I'm going to put up exhibits number 24 and 25. And when you sort of take all of the information sort of combined together between the various wounds and the blood at the scene, can you draw any conclusions about sort of the sequencing of events that occurred inside apartment 432?
That's, I would say, let's go for the reasons testifying. If it's within another report, that's fine.
Well, I mean, you can lay a little bit more foundation as to how he did this rather than what his background is in doing this. I'm not saying you can't do it, but I haven't heard enough now to have him make that statement.
Detective, in the course of your career, in the 14 years you're in homicide, is review of crime scenes something that you did?
Yes.
All right, and can you explain to the ladies and gentlemen of the jury, when you're standing in a crime scene, are there certain things that over the course of your career you learned that you could sort of make determinations or inferences from the physical evidence that's present at the scene?
Yes.
How do you go about doing something like that?
Well, obviously, there's a lot of training that's involved with what we experience as detectives throughout the time that we're homicide detectives. There's also then being present at numerous crime scenes where you develop your sense for what happened in the room, and you develop a scenario on how you believe the items of evidence became deposited, where they became deposited.
Okay. Let me ask you this, are the conclusions you're able to draw based solely sort of on a logical inference from the evidence that you see?
Yes.
A person is not normally, does not normally expel blood unless they have an injury, for example.
That's true.
So if you find blood at a scene, you know that someone's been injured, correct?
That's right.
If the blood is like it is in this, in State's Exhibits 24 and 25, the height of the blood, the size of the blood drops, those type of things, is there information you can gather from that?
Yes.
And in the course of your career, how many times have you stood in a scene and sort of taken in all the various things that you can learn from the investigation or from what the physical evidence is, and sort of drawn conclusions about how it is certain things went down?
Well, literally hundreds of times. Some of them before autopsy, some of them after autopsy, because learning about the characteristics of the wounds will help you revisit the scene and learn more about the scene and what occurred.
So let's talk about, have you ever heard the term cast-off before?
Sure.
And when we use that term, what does that term mean to a homicide detective?
Cast-off for us is pretty simple. It's the fact that an action occurs after a strike or an injury is dealt to the victim, such as a blow by a hammer or a heavy object to the head would create a cast-off because of the wound. The item used in the striking would bear some of the blood, and as it was removed away from the wound area, it will bring blood away with it, and some of that blood can cast off to a neighboring object, clothing or a wall, or even the person doing the striking. So that's what cast-off is.
And when you look at the height, the size of the blood drops, the directionality of the blood drops, can that all lead you to some logical conclusions about what did or didn't happen in the scene?
Yes, I mean, certainly if we have blood droplets that are at the 6-foot level or the 4-foot level, we could determine possibly the height of the person that was bleeding that the cast-off came from, or the hand of which the wielder of the weapon was using to do that cast-off. There's other environmental things in the room that could cause the cast-off to fall in different places. Ceiling fans spinning or an air conditioner on all affect those droplets that could possibly fall to a different location. So cast-off is, as I said, important for us when we revisit the scene.
And in the course of your career, have there been hundreds of scenes where you've sort of taken all of the evidence that you gathered during the course of the investigation and gone sort of either back into the scene or from photographs and sort of reviewed all that and sort of tied it all up to see could there be any conclusions drawn about the nature of the actions that occurred during the course of a homicide?
Yes. With the exception of outdoor scenes, usually we always revisit an indoor scene because we learn so much at autopsy. That's the reason why you saw the orange tape on the windows that allow us access back into our crime scene. We don't just give up after we're done with the first investigation. We learn more information from the autopsy about the damage done to the victim and then go back to the scene. As a matter of fact, that was when the luminol was done, was the second visit. So the blood cast-off makes more sense after you've understood the wound characteristics that the victim had.
For example, one of the wound characteristics of this victim was a blunt force trauma to her head.
That's true.
And then there is a number of stab wounds, at least a good proportion of which suggest the victim's not moving. Is that correct?
That's correct.
And the fact that she's wrapped up in blankets and the bedspread, does that tell you anything?
Well, it would tell me that the bedspreads,
Once again, this witness was a summary witness of the investigation of what happened, not what he thinks happened 31 years later. That was the whole purpose of his testimony, was you allowed it in
All right, well,
summarizing. So now we're off.
No, I mean, I'll let counsel have him refer to specifics in the photographs or details and deductions that he can come through based upon his experience and training. So I'll overrule.
What do the bedspreads and the blankets suggest to you about the crime?
the bedspreads and the bed itself indicate there's a secondary location for a second attack. Because the first attack is here by this window, when this victim is upright and bleeding in this location near the window.
And how do you know that?
Because how varied and how spread apart those droplets are. That victim is up and on her feet, struck in the head, possibly bleeding out, and then the majority of the wounds occur on the surface of the bed.
And you have blood on the mattress, she's within those, and she's not moving once those stab wounds are occurring to her.
That's true.
Does that suggest to you that she was hit over the head and then taken to the bed area?
Yes, that's what I'm seeing when I look at this, that there's an attack that occurs here, and then the victim is moved to the bed.
Robert, well, I'm going to review the objection.
All right, I think I'll sustain the last and strike the last answer. I think we've gone a little far, but before that, I have no problem with it.
Thank you. Now, Detective, you said that you had an opportunity to review the trial transcripts in this particular case.
Yes.
And Judge, we've had marked and shown to counsel the trial testimony of Roger Blackwell, which is State's Proposed Exhibit 62, Virginia Lee Pratt, which is State's Proposed Exhibit 63, Barry Coslett, which is State's Proposed Exhibit 64, Ron Castle, State's Proposed Exhibit 65, Brenda Gagliardo, State's Proposed Exhibit 66, Bill Childers, State's Proposed Exhibit 67, Dave Hatch, State's Proposed Exhibit 68, Martha Swerble is State's Proposed Exhibit 69, Nancy McGilvray, State's Proposed Exhibit number 70, Daniel McConnell, 71, State's Proposed Exhibit 71, Catherine Atkins, State's Proposed Exhibit 72, Thomas Dillard, State's Proposed Exhibit 73, Minoru Aoki, State's Proposed Exhibit 74. That statement came out of the back of 74. State's Exhibit 75 is the testimony of Bill Lieber, and State's Proposed Exhibit 76 is the testimony of Bob Leonard. I'd offer him at this time.
All right, that's exhibits what through what?
62 through 76.
All right. Does Vince have any objection other than those previously voiced?
Your Honor, if we can reserve our objections at a time where we can do it in detail, not from the jury.
All right, okay. I'll reserve then on that and let you bring it up at a later time. We'll not, the jury's not here. Not at the moment.
Detective, the only area I didn't cover was the forensics that was done by Mino Aoki. Do you know who Mino Aoki is?
Yes, throughout my career as a homicide detective, Emilio Aoki was one of the senior individuals that worked in the laboratory at the Las Vegas Metropolitan Police Department.
And back in 1986, he was a forensic analyst who did comparisons both of the blood in this case as well as the hairs.
Yes,
And during the course of his testimony as well as the reports that you were able to read, was he able to determine that, as we said before, there was human blood within the apartment, but he could not do anything else with it because of the limitations of technology.
that's true.
And then he found from autopsy that he found a hair consistent with Brenda Gagliardo, as well as hairs consistent with the animal hairs collected from the dog and cat.
That's true.
From the car, he found hairs consistent with both the defendant, John Valerio, and Brenda Gagliardo.
Yes,
From the blanket, he found a number of hairs consistent with Miss Gagliardo as well as the defendant.
yes,
And the bloody sock. On the bloody sock, he found a hair consistent with the defendant, is that correct?
yes,
And then the bloody sock, during the course of the search warrant at the house, was the mate to the bloody sock provided by Miss Gagliardo.
yes, it was located in the house.
That sort of completes my questions about the homicide itself. Were you also, and I think you mentioned this before, previously provided information about Mr. Valerio's two prior convictions, the 1983 attack upon Mr. Henderson and the attack on Ms. Howell?
Yes,
Judge, I have in my hand what's been marked as State Proposed Exhibit Number 80, which is the pre-sentence investigation report, convicted person questionnaire, and United States Department of Justice Federal Bureau of Investigation Identification information from that 1983 incident I offered at this time.
The objection beyond what's been previously raised?
Yes, Your Honor, if you could hold up.
All right, I'll reserve for the moment on this one.
Mr. Vaccaro, during the course of your review of this information, did you learn that Mr. Valerio had served 23 months upon his robbery conviction for Mr. Henderson?
yes, I did.
And that he was released in 1985, is that correct?
That's correct.
And that he was still on parole on the date that he attacked Angela Howell?
That's correct.
Did you learn through the records contained in there of the Las Vegas Metropolitan Police Department that when he was booked on the parole violation, he was also booked on a number of crimes related to Ms. Howell on August 10th of 1986?
Yes,
And that he was released from custody on August 29th after posting $8,500 in bail?
yes,
And so at the time that he kills Karen Sue Blackwell, he's on bail from the charges associated with the Angela Howell attack.
that's true.
May I have the court's indulgence?
Go ahead.
Thank you. Thank you, sir. I pass the witness, Judge.
All right, cross-examination.
Mr. Vaccaro, there was a picture up here with some items, I think it was just up there you were talking about, and you said that the incident is always revisited. Remember you were asked about those little spots of what you said, the report said were blood?
That's true.
Okay. And you said that it is always revisited?
Yes,
Okay. Now, which officer in this case revisited that to make the determination that you were relying upon when you told the jury about the blunt force? What officer did it?
what else, we went to the scene?
No, what officer did this revision that you always do, that you told us? You just told us.
Right,
You said an officer always revisits it, and therefore my statements today is nothing more than what they revisited 31 years ago. Who was it? I don't see that in all of the testimony or all the reports. I see no revision.
That's my understanding that the lead detectives on the case revisited it.
Well, did they revisit it and say that about the blunt force?
That's my impression that they had been there. I
They
worked with
had
these-
been there.
Yes.
Not that they made the conclusion you just told us that they.
I don't know what their conclusion was. For sure, I know what I did by looking at that photograph.
Well, I guess that's the problem I have. You've come in 30 years later, 31 years later, right?
Yes.
You're telling us what your opinion is now 31 years later, right? That's not what was introduced 31 years ago, was it?
Well, I wasn't part of the case in chief for all of the testimony. I don't know if it was introduced or not.
Well, you have to know if it was introduced, because you just told us. What you're doing here is, you went through everything in this case, 30 years later, and now you're telling us, geez, I don't know if it was.
Well, I believe that's what occurred there at the door.
Well, as you occurred, I'm asking you, in your review of this, when you just told us that homicide detectives always do this review, I'm saying to you, it wasn't done in this case, was it?
I don't know that it wasn't done.
Well, did you review it?
No, I'm telling you that I saw those photographs and I believe that's what occurred there.
That's not what I'm saying. And that's not what you said. You said it's always reviewed by the detective on a closed room thing. And all I'm asking you, quite simply, is, isn't it true? That wasn't done in this case.
I know I never said the words closed room. I know those detectives reviewed those photographs.
But you didn't see any conclusion like yours, did you?
I didn't read that they concluded that.
Well, did you read what they said, didn't you?
I did.
Okay. And so this conclusion now is one that you've come up with 31 years later?
I have reviewed the photographs and I do have an opinion on that, yes.
All right, when did you come up with it?
I believe that since the day I was there.
Well, were you at the house?
I was at the house.
Did you look at these photos?
I have recently, yes, but I've...
Recently looked at them. When did
Yes.
you recently look at them?
Over the course of, I've been subpoenaed on this since December of last year.
Okay. So from December of last year to the time of this incident, that's about 30 years, right? Right?
Objection or unanimous?
That's good enough.
I mean, overrule, you, but I think everybody knows how long this has been.
All right, well,
But you can ask them how long
Sure.
it's been one more time.
all right. Now, I want to go to this. You've come in and you've testified, and you're supposed to be a summary witness, right?
Yes,
You were asked by the state about a year ago, let's say a year ago, year and a half ago,
it was prior to the start of this year.
okay, prior to the start of this year, so it could be within a year, around a year.
Yes,
All right, to look at these, look at this stuff, correct?
that's correct.
Now, I want to just go back to, you weren't a homicide detective at the time, were you?
No,
You had not been in homicide at the time, had you?
no,
You were a general assignment detail detective at this time, right?
that's correct.
You said you were TDY to general detail.
That's right.
And your involvement in this case that you've testified to for the last hours is not based upon personal knowledge, save and except when you were in the interrogation room with Mr. Valerio and when you had those photos taken of his back, correct?
That's absolutely not correct.
Okay? Now, let me ask you this. Did you go to the scene where Officer Stubbs was?
No,
Did you see the car where Officer Stubbs said he found the items?
no,
Did you review Officer Stubbs' reports?
yes,
And in that report, you saw that Officer Stubbs had set up on that car because there are a number of outstanding warrants, correct?
yes,
But you weren't there.
no.
So all the testimony you gave us about Officer Stubbs is based on what you've read 30 years later.
I don't know that I gave a lot of testimony about Officer Stubbs.
Well, you gave some, didn't you?
I just recall mentioning the location the car was found.
Okay, so but that was based upon your review, as you said about a year ago.
Well, I was aware of that from the inception of this, the arrest of the defendant.
Did you look at this statement?
I have, of course I have.
When?
I have recently reviewed
Okay.
it, but in the case in chief, during that time, whatever year that was, 30 years ago, I was aware of the location of the car and Officer Stubbs finding the
You
car.
were not one of the homicide detectives, were you?
No, but I testified in that matter.
All right, and all you testified to in that matter, well, you didn't testify concerning Officer Stubbs, did you?
No, it doesn't mean I wasn't aware of what happened.
I asked you, did you testify?
Okay, I won't argue with you, go ahead.
Okay, you testified about Officer Stubbs.
I didn't need to, he did.
Okay. Let me ask you again, maybe get the answer out this time. Did you testify
But I
about Officer
object-
Stubbs on that
I'll
trial?
sustain that, just focus on questions.
Did you testify concerning Officer Stubbs in that trial?
No.
No. The only thing you testified in that trial, as we got the transcript, is the incident with the hatch in the interrogation room at the Detective Bureau and when you had those photos taken, correct?
No.
What else did you testify to?
I testified to the apprehension, being present at the apprehension of Mr.
Okay.
Valerio. Would you like me to go on?
Okay, what else?
I testified to being present at the time of his arrest and taking him and transporting him to the
Okay.
Detective Bureau.
We did say that, you brought him into the Detective Bureau.
Right.
All right, now let me ask you this. Let me go now from Officer Stubbs, of which you did not testify to, and you, to the best of your knowledge, last time you reviewed his report was within the past year.
That's correct.
Now, let's go with the, at the Naples area, where you said that you were on a stakeout, if you will.
Are we talking about Officer Stubbs? I'm sorry, I'm confused because he was
Well,
at
I'll
Naples.
try to confuse you. All right, let's go back to Naples. You know where Naples is?
I do.
Okay, is it Officer Stubbs wasn't in Naples, was it?
No.
So when I asked you about Naples, you knew I weren't talking about Stubbs. Right?
Yeah, he said
Okay.
Officer Stubbs.
Now, when you were at Naples, you did not observe the incident with Hatch, did you?
No.
You had left by then.
I was present at the scene prior to leaving there. I had been at that
Oh, I
location.
understand, but you didn't see the incident with Hatch.
I didn't see the actual shots fired, no.
Okay, so you didn't see the car drive towards the Hatch as you testified, did you?
I did not.
Okay, so when you were testifying about the situation with Hatch, you were just relating what Hatch told you.
I related what I learned from the reports and what Hatch told me. Yes.
So basically, all you're doing today, many years later, is saying what Hatch said.
I'm summarizing the incident,
And that was based upon what Hatch said.
what he said and what the reports indicated, yes.
Well, those reports that indicated it were Hatch's reports, weren't they?
Well, there were numerous reports. There were crime scene investigator reports. There was a supervisor's report about the shooting incident. There were numerous reports about that.
All right, and who besides Hatch wrote a report as to the, what he is alleged Valerio did to him?
Certainly you have that. That's Sergeant Bunker's report.
Oh,
authored by-
Bunker wasn't there either, was he?
Bunker authored a report about the shooting incident.
But he only offered it based upon what Hatch said.
Well, that may be, but it's still another report.
Okay, was there anyone besides Hatch that was an eyewitness to what happened that wrote a report?
No, and I think I was clear about that. There was no one there but Hatch.
What's that?
I said, I think I was clear about that. There was no one there but Hatch.
There was no one there but Hatch, and therefore, the facts about what happened came from Hatch. No, whether it was Hatch's report, or Bunker's report, or anyone else's report, right?
Right.
Okay. So when you were testifying to that, you were basically just repeating what someone else has said.
What I learned from Detective Hatch and what I learned about the scene, yes.
Well, when you say learned, all you did is you're regurgitating, if you will, or throwing back to us what you're saying that you discerned out of the report, right?
No,
Outside of Hatch, there's no one there. Now, then you talked about, the, where was it? The photos that showed where the cones were on the street, right?
correct.
Did you go back to that?
I was there.
Okay. But those cones were placed after you went back, correct?
Those cones were placed and then I went back to it. They were already present.
They're already there. And that what you said was a cul-de-sac?
Yes,
And so a cul-de-sac, there's only one way in,
yes,
and there's only one way out.
everyone I've ever been on.
Okay. So when the person was leaving or driving, it was towards the exit of the cul-de-sac, correct?
Which person, sir?
The person you've identified as Mr. Valerio.
In- My understanding is that when he left the cul-de-sac, he left by the open end of it, which was
Okay.
towards Paradise.
And I didn't see in there, was there a picture of where Hatch's vehicle was?
I didn't see the photograph of that either.
Okay. So we don't have any photographic evidence, at least here or here, that tells us where Hatch's vehicle was doing.
Well, it was inconclusive because he moved it.
It was what?
It would have been inconclusive to the scene of the shooting because he had pursued after Mr. Valerio and then returned back to his shooting location and reparked his car.
Okay. So, but there's nothing that indicates a photo where he had the car returned.
I believe there is one. There's a photograph, I've seen a photograph of an open door on a police car with a shotgun on the front seat. Now, I can't tell the proximity of it on Maples, but there is a photograph of the car.
You know when that was taken?
That night,
Was it after this incident?
after the shooting, for sure,
So you didn't see the shotgun yourself?
I saw the photograph. I know his car was there, and I know that they were conducting the investigation on the street, yes.
Now, when you talked about the, let me ask you, did you go to the Naples apartment?
Yes,
Huh?
yes.
Okay, when did you go there?
There was a period in flux between the arrest time and the determination of whether or not the search warrant was prepared to lock down the Naples address and to be able to enter the address to begin an investigation, and before my transport of Mr. Valerio to the jail, or to the homicide office, rather.
You weren't part of the search.
No, not really. It wasn't my scene, it was the homicide detectives that were called.
So they're the ones that went.
I was present there, but I wasn't part of the search.
Now, I want to talk then about the autopsy. You testified about how an autopsy, of the procedure of an autopsy.
Yes, yes,
That is to say, you say the detectives show up.
yes,
And you said that was, to the best of your knowledge in reviewing the reports, Tom Dillard and Bob Leonard.
yes.
Okay?
It is usually routine that one or both of those detectives are present at the autopsy.
Do you remember which it was?
No, I don't.
Okay. You weren't there.
No.
So when you were talking about what was happening at the autopsy, you weren't there, correct?
That's correct.
It's based upon your reviewing these records, as you said, within the past year.
Yes, sir.
Okay. Now, you were asked certain questions concerning the, some of those photos, correct?
Yes.
Now, you'll agree with me, well, maybe you won't. We'll see.
Probably not.
Probably not. You haven't in the last 40 years, have you?
Doing the best I can.
I understand. I understand. But in those things, you'll agree that an autopsy is conducted by a licensed doctor.
I think they are, yes, sir.
Okay, they're called pathologists,
Yes,
and it's done by the coroner's office,
right,
and they're the ones that have medical background.
yes.
You don't have that medical background, do you?
No, I don't.
So what I'm saying is that the conclusions that are made by a medical doctor are conclusions that you would have to defer to.
Yes,
You would not want to let us believe because you were somehow in future career or homicide detective that you had medical expertise.
I do not.
So when you were testifying here today and you were talking about what this wound means and what that wound means, what you were doing is you were just trying to, I guess, summarize what you thought the medical and reports said. Is that correct?
Well, I reviewed the photographs and the reports that were about the autopsy
Okay.
and used my personal experiences as a homicide detective to reflect upon those and then give my testimony today.
But the conclusions that were drawn at the autopsy were drawn not by you weren't there. They were drawn by the pathologist,
That's true.
not you.
That's right.
And you would defer to the conclusions of the pathologist,
That's correct.
or any medical person who, any medical person, correct? Medical doctor.
I would agree with that.
All right. Now, in there, you were then asked about a blunt, what the prosecutors call a blunt force instrument, right?
Yes.
And you had mentioned a hammer,
I just use that, just comes to mind.
and you know specifically at the autopsy and the testimony of the doctor, it was specifically said it wasn't a hammer.
Oh,
You don't
I'm aware
remember
that
that?
they specified it, not a hammer.
Okay, you don't remember seeing anything about a hammer in the testimony of Dr. Hollander?
I don't recall that.
When did you last look at her testimony?
I don't recall how long it's been. That may have been early on when I first received the information.
And you saw in the autopsy and in the photos and the reports that what they do is they actually look at the brain, they expose the brain.
Well, yeah, there's a cap of the skull removed and the brain is removed from the skull. In this case, from my recollection of the reports, is the brain was liquid.
Okay. And isn't it true from your review of the reports and what Dr. Hollander said, there was no injury to the brain?
I don't know that that's the conclusion Dr. Hollander made. If she did, I didn't read that in the report. I remember her saying the brain was liquid.
Okay. Now, when we're talking about an injury to the brain, we're talking about a blunt force trauma to the head.
Yes.
The function of that, of course, is does it then bruise the brain, right?
Well, no.
It could, right?
I
If
guess
it's a
you could.
sufficient, I'm sorry, if it's a sufficient force injury to the head, it would have some sort of marking or ramification of the brain, wouldn't it?
Well, not being a doctor, which we already know, I'm not really sure I can answer that question.
Well, let me ask it this question. When you read all these reports, you saw that there was no indication that there was any trauma to the brain from a blunt force object, right?
Well, I think I just testified that the brain was liquid because of the decomposition. It had no physical substance to it to be removed from the skull cavity. And so I don't know that a determination was made that there was no brain injury at all.
You saw nothing that would indicate there was.
And my readings of Dr. Hollander's report,
Right. So you saw no indication that there was.
I don't recall that there was.
And so when we went through these photographs and you were talking about these items, once again, you're doing this well after the fact, and we defer to Dr. whatever the medical personnel is that testifies.
Yes.
Okay. Now, you had mentioned also, about the reports that you went through concerning a man called Roger Blackwell.
Yes.
And did you interview him?
No.
But you read his interview?
I did.
Did he explain to you, and you said that you testified at the direct examination, that he knew that Karen Blackwell was a prostitute?
That was my understanding from what I read, yes.
Okay. And that you told us that he was the one that knew about the trick book?
It was either him or the current boyfriend.
Okay.
I believe it was, I think he knew, but the boyfriend for sure knew about the book. But I believe it was the husband as well, so
Okay.
we could maybe clear that up.
Okay, so maybe if I could, so what we had, and this, the husband, Mr. Blackwell, is the father of the 9-year-old girl?
That's my understanding.
Do you know if it was ever asked why he would leave a 9-year-old girl with a mother who was a prostitute, was out turning tricks and leaving the child?
I do know which letter he is.
That's sustained.
Now, the trick book, wasn't that by Mr. Blackwell? He was the one that talked about the trick book?
like I just testified to, I believe that it was Mr. Blackwell that brought the trick book to or to the detectives at the time, to their knowledge about how she operated in her business.
Okay. And then that's Mr. Blackwell. He lives in Las Vegas, or he lived in Las Vegas.
Right.
And then we had a boyfriend,
True.
and he lived in Texas.
Right.
And I take it that he confirmed also that she was a prostitute?
Yes, he confirmed that and a phone call on the night of her death.
Now, going back to Officer Stubbs, and you were aware of these warrants and reviewing his report, and that he was surveilling, I guess, if you will, the car on that night. Did you see any interviews of William J. Roof?
I know there is an individual that was associated with the apartment complex where the car was found, and that name sounds familiar. And if it's that individual you're speaking about, I'm aware of an interview by the lead detectives with someone that resided at the complex.
And that is on that relationship with Karen Blackwell?
No, I don't know that.
Now, the last thing of what we're doing is, and you said she had many names,
Yes.
and we saw all those newspaper ads. You were in Vice at one time, weren't you?
No.
Oh, you weren't?
I'm happy to say I
Yes,
never was
sir.
in Vice.
Okay. And we've identified that was Ms. Blackwell, correct?
Right. Right.
Now, you were brought up when we came back from lunch, the issue of the conversation with Mr. Valerio, right?
Yes.
Mr. Valerio said that when Hatch was pointing a shotgun at him, he said he didn't know who he was.
It wasn't words exactly like you just said, but I did put them down as best as I remembered them on that occasion,
Right.
in my report.
I understand. And you put down, he said to you, what would you do?
Yes.
He said, some guy tells you to put your hands up and freeze, you're under arrest, and you don't know who he is. That's what you were told by Mr. Valerio, correct?
Yes, that's, are you reading from my report, sir?
Absolutely.
That's exactly what he said.
Except he also said, and I just took off.
That's right.
So that's what he told you about the incident, correct?
That's right.
And he had, in fact, you said there were abrasions, if you will, or wounds in his back, or his back hurt.
Upper left arm, left side, and a distinct wound on the back
And
of his
we
neck.
saw those photos.
You did not, yes, sir.
Yeah. Now, you told us an interesting thing, that the statement that Mr. Valerio makes, you said at the Detective Bureau, that he hadn't said anything up until the time Detective Hatch puts his head,
That's true.
right? And now Detective Hatch is a sworn police officer.
Of course he is.
We're talking about the same Hatch.
Dave Hatch.
Yes, okay. And what the police officer does while you were sitting with the person we'll call a suspect, right, who was handcuffed to a table, as I remember,
Yes.
is that he comes in, the detective comes in and points a finger and cocks his thumb, correct?
That's what he did.
Yeah. And indicating of shooting a person, right?
Yes.
So he comes in, the detective comes in, indicates that he's going to shoot Mr. Valerio by his fingers, correct?
Yes.
And then that's what gets Mr. Valerio gets excited, right?
Well, let's not take that out of context too, because you just
No, no,
said
let me
that
ask
he
you a
shoots a
question.
person.
Let me ask
some
a question.
questions.
Okay.
Mr.
Okay.
Giacomo can ask you on redirect.
Well, the context is you've already testified he's sitting there and he's not doing anything but sitting there, correct?
I think,
Isn't that true?
go ahead, ask me that question again,
All
please.
right, isn't it true that Mr. Valerio, prior to the time Detective Hatch pops his little head in, is sitting at a table handcuffed to the desk?
Yes.
He's not said anything,
No.
okay? And so the context is, then Hatch puts his head in and makes the shooting
That's true.
gesture.
That's true.
Now, you've been a detective for how long?
Well, I've been on approximately 10 years at that time.
Okay, but you've been a police officer for quite a while in your
Yes.
career,
Well, 30 years and...
30-odd years.
And a little bit.
And that just seems awful strange unless, or is this something that Hatch is noted for?
Obviously, Hatch, having experienced what he had, came into the room with some emotion and made that gesture towards Mr. Valerio.
And he should have.
And a couple words happened, and I, out of respect for a senior detective to me, just closed the door. We went back to our peaceful little sitting there.
Well, what you told us before was that Hatch was yelling at Mr. Valerio when he put it in and made the shooting, and that it got loud.
What I said was, there was an exchange that I don't recur I don't recall exactly, of a few more words after the gesture was made, and then Mr. Valerio said, I tried to hit you, or should have hit you, or I tried to hit you, which is in my report as well.
Right.
And then I knew what was going to happen there, and so I just got between them and I closed the door.
Well, you can't, Mr. Valerio can't go anyplace.
Well, I know, but I could close the door and not let Detective Hatch in, and it was a lot less abrasive than I think it's being portrayed as right now.
Well, you were the one who told us on direct, when the government asked you these questions, that it was loud, and that Hatch was loud, right?
I said it was a verbal exchange. I don't want to have a read back on it that I said loud, but it was a verbal exchange.
Well, it was loud, wasn't it?
Well, they got louder than sitting there in silence, yeah.
Yeah, and Hatch got loud. Right?
You want me to say what Hatch did?
Yeah, Hatch got loud.
Hatch said a few words to him which were louder than us sitting there
Yeah.
in absolute silence, yeah.
And you don't know what those words were.
No, I don't recall.
You don't recall 30 years later.
Wish I could.
Yeah, so do I, because you seem to recall all these other things, but when it comes to a senior detective making a gesture like that to someone that is handcuffed, you don't remember.
I know what happened.
You don't remember.
I do remember what happened.
Do you remember what he said?
Not every word of it.
And then when we were talking about Hatch and the shooting, and we showed pictures of the car,
Yes,
all right, the picture of the vehicle we saw had the back window blown out.
yes,
And that back window was blown out by this detective who has a shotgun and shoots at a vehicle. Right?
yes,
And for him to shoot at the back of the vehicle had to have been past him, correct?
yes,
So what he's doing is with a shotgun out there, blowing out the back with a shotgun of a vehicle that is past him, right?
the vehicle's, I mean, based on the impacts to the vehicle has passed him and he's fired a shot from the rear, yes.
And well, he fired more than one, didn't he?
Yes,
Fired what, 3 shotgun blasts?
3 shotgun blasts.
And then later comes in as an altercation with Mr. Valerio, who's handcuffed, and you get him out of there, out of respect for him being a senior police officer. correct?
No, I just took a position so that I could stop what was happening here, that's all.
Now, you know what blood spatter is?
I did.
What is it?
Well, there's blood spatter and blood splatter. Would you like me to talk about both of them?
Well, we'll talk about both of them.
All right, well,
What's blood spatter?
spatter is what it is, and splatter is what it does.
Okay?
So,
Now, my understanding is that Metro has experts on that?
we've all been trained, so I don't know what level of expertise you want to go to, but our crime scene investigators certainly see a lot of blood spatter and a blood splatter marks indicating the blood spatter.
And in this case, you weren't the blood spatter or splatter expert, were you?
No,
And I think that you haven't actually been qualified as a blood spatter expert in blood, have you?
no,
And what we're talking about, we've got about blood spatter and the expertise that is involved in there. It is the ability to determine what the effect of droplets of blood on an object are, correct?
that's correct.
Now, you talked about you were talking about blood, and obviously, I'll ask, you're not an expert in blood, are you? That is the analysis of blood.
No, I've never been formally declared an expert in blood.
Okay. And you don't run tests on blood to determine what it is or isn't?
No, sir.
Okay. And going back, way back when to 31 years ago, that far back, we didn't know about, for example, DNA analysis.
Well, no, it wasn't that I'm aware of until probably the early 90s that I used.
And so when we're going back to this, you have no expertise to say that a particular spot of blood is an individual person, do you?
I did not have the ability to do that. Typing was present then, though.
Okay. But in this case, they did not do any typing as to Mr. Valerio, did they?
I don't recall if they did or not. As to Mr. Valerio or to Ms. Blackwell?
Blackwell.
I believe typing was done.
Was there any testimony in what you read that said that any of the blood was hers?
I don't recall. I don't think I testified to that, no.
I know you didn't testify to it, but
I don't
I
recall.
have to rely upon what I've read too.
Okay.
All right, so there's nothing to say that. No. So the point is that when we start talking about blood and where it is, in this case, we can't say even when a spot of blood was there, right?
No, I mean, it's certainly an argument that blood has a life at a particular location, but
Sure.
we can't say how long it was there, that's
Okay.
true.
Now, you've been involved in homicide cases, right?
Yes, sir.
And you're involved in a case called Margaret Rudin?
Yes, sir.
And you remember that in that case, on the ceiling was some blood, right?
Yes, sir.
And you remember that blood had actually been put there like 10 years before, when the first Mrs. Rudin killed herself in that bedroom, right?
No, that's absolutely wrong, Mr. Patero. Sorry. There were two elements of human remains on the ceiling in that bedroom in Rudin. One was the blood of Ron Rudin on a cover over an electric outlet. That was from the
Not on the
instant case.
ceiling.
Yes, it was.
No, it was Mrs. the first Rudin.
Sorry, I lived that case like you did. And the other blood was Peggy Rudin, a wife of Ron Rudin who committed suicide. And I don't know if it was blood or brain matter, but that's
How
my
long was it?
recollection. Pardon me?
I mean, it had been there for years, hadn't it?
Well, the brain matter allegedly had been there for years, sure.
So what we have is you have no way of, as you testify here today, we're not going through it for purposes of what is or isn't in terms of whether it was or wasn't determined. We're going through that it wasn't determined at the time, was it? Whose blood it was.
All right, let's talk about
Is that
that.
correct?
I'm not going to answer you until you clear up which case we're talking about.
Okay.
You talking about
Well, we're here
Rudin still?
now. Yeah.
On
All right,
Rudin?
let me start over.
Everything was clear on Rudin.
What?
Crystal.
You're aware she's getting in trial.
Objection.
Sustained.
Is that a statement too?
That's, I'll
All right,
strike the statement of counsel.
all right. I apologize, Mr. Vaccaro.
You should, sir.
I should. The issue with it is that we don't have any way then or, and has not been done since, as to individualize anything that is in that room on the Naples.
Anything,
Well,
including stain of blood?
The blood. Is that correct?
I don't know that those tests were conducted. Certainly typing could be done on the blood evidence that was in the room and on the mattress.
Did you see it?
I did.
Okay, so you reviewed it, and so I'm assuming because you seemed very thorough, if you didn't mention it, you don't remember, it's probably not good.
Thanks for the compliment.
You got it.
I don't recall, no.
Okay. You also talked about hair, and Mr. Aoki,
Yes,
and he talked about, you kept using, you were asked the question of consistent, right?
it was consistent with.
You're consistent with. Now, you know that all consistent with really means is, it's like it.
Well, okay, your words, okay.
Well, you know that consistent doesn't mean it is anything, do you?
Well, I know it can exclude some
It
things.
could be exclusionary.
That's true.
Okay, for example, you and I are consistent, both of us, you not as much as me, but lost hair. That's sort of consistent, right? But that doesn't harm you, does it?
Is this going into a weight thing too soon? Because,
No, I never go to weight.
Mr.
I never
Vaccaro,
go to
let's,
weight.
hold on.
okay,
So answer the question. Let's focus
So-
on questions.
The issue of consistent, that is not a definitive term, is it?
no,
And based on your experience as a detective with a homicide, drugs, or whatever, we know that the term consistent means it's not definite, correct?
yes,
It could or it couldn't be.
that's true.
That's the best we can ever get out of it,
That's fine.
all right? And so when we say something is consistent to the jury, all you really mean is it could be or it couldn't be, correct?
Yes.
I have the court's indulgence,
Sure. Take your time.
you had mentioned a weapon, a gun.
Yes.
A gun didn't come into play in this case, did it?
No.
And the testimony that you relayed in this summary fashion was testimony that had been determined many years ago, correct?
Yes.
Right, so we're not in here trying to relitigate that out.
No, sir.
Now, the one thing too is, you were showing a picture of a tie, you called it, around the person, and it was loose.
Yes.
And you said it wasn't a ligature.
I did not believe it was illegal.
Okay. And you were then asked, was there anything that you were aware of in any of the reports that would show that there was anything, that there was any marking on it?
I don't believe it was from
And it
that.
was-
From that. No, sir.
I have nothing further, thank you.
All right. You ready?
Briefly. There was a lot of questions asked about, oh my God, why isn't Dave Hatch here? Do you remember those questions being asked to you?
Yes.
Do you know where Dave Hatch is today?
Yes.
And can you tell us where he is?
Dave's having a bout of cancer, and he's not healthy.
And in fact, he's not capable of coming to this courtroom.
That's true.
Objection, that's.
Sustained.
Is he available for this trial?
To my knowledge, no.
Detective Leonard.
Sustained. We're going to need to lay a foundation, and that's a legal conclusion at this point in time, so we're not going there, counsel.
Maybe be heard of at side park?
All right.
Based on the court's ruling, I have no other redirect.
Okay? There was a few questions, any recross?
No, Your Honor.
All right, ladies and gentlemen, as I mentioned earlier today, you are allowed to ask any written questions. The witnesses are here. If you want to ask a question, write it on a clean sheet of paper with your juror number and raise your hand. Marshal will pick up the questions. Questions should be addressed to the witness, not to the court or to the attorneys. I'll get to the attorneys after you have any questions and see if we feel it is appropriate to ask. If it is appropriate to ask, I will ask the question. No undue emphasis should be placed on questions that you, your colleagues ask, and no special consideration should be given to the fact that I decide not to ask a question. Does anybody have a question for this witness? Not seeing any hands. All right, last chance. Thank you, sir, for your testimony. Your excuse.
Thank you.
All right, state may present its next evidence.
Judge, the state's going to read the testimony of Dr. Nina Hollander. We have a witness here to play the part of the doctor. As she's approaching, showing the defense counsel with remark to state influences 52, which is a diagram from the autopsy note for his admission.
Hold on a second. While you're discussing that, we'll go ahead and swear in the witness to do the reading.
Do you solemnly swear that you will well and truly read the answers of the witness as set forth in the transcript in response to the questions therein asked by counsel, so help you God? Please be seated. Please state your name and spell your first and last name for the record.
Nina Hollander, Ninahollander.
We need you to.
Oh, my name?
Yes.
I
so you're-
apologize.
As the reading witness, we want you to give us your name.
Sorry about that, Judge. Lisa Luzach, Lisa
Okay. Now, you're moving for admission of,
Yes, Judge. What was states 69 at the first proceeding is now states 52, which is the diagram utilized by the doctor during her live testimony in 1988. For the diagram of the body where the injuries were. And with the image.
all right, any objection?
None beyond what we've already projected.
All right, 52 will be admitted.
I'd ask if you can switch it over, that question first. Would you please state your name and spell your last name for the court reporter?
My name is Nina Hollander, Hollander.
What is your profession or occupation?
I'm a medical doctor. At present, I am deputy medical examiner in Clark County.
What is a medical examiner?
A medical examiner is a person who determines the cause and the manner of death in people who are brought into the office.
Dr. Hollander, would you please tell the jury a little bit of your past qualifications and experience that will lead you to be able to render opinions on the cause of death?
I received a medical degree from New York University School of Medicine. I have had training, residencies, and experience in pathology and forensic pathology. I have taken examinations. I am board certified in both specialties of pathology and forensic pathology. I have worked in medical examiner offices since 1970, first in New York, then in Texas, and since 1985 here in Clark County.
During that period of time, you've worked in medical examiner offices for 18 years, going on 18 years?
Yes,
During that period of time, how many autopsies would you estimate that you have performed?
between 3,000 and 4,000.
And in those autopsies, did you render opinions as to the cause of death of the particular victim in the autopsy?
Yes,
Have you had an opportunity in the state of Nevada to testify in the various courts?
yes, I have.
And in so doing, have you qualified as an expert in the field of pathology?
Yes, I have.
How many times?
Approximately 60 times.
And each time you have been qualified as an expert in the area of pathology?
Pathology and forensic pathology.
Thank you. I would submit Dr. Hollander, judge, as an expert witness in the field of forensic pathology. Response was, I have no questions of her in the court. I don't wish to examine her on board the answer no. All right, you may proceed. Dr. Hollander, on the 30th day of September 1986, did you have occasion to perform an autopsy?
Yes, I did.
And allow me to show you a photograph marked State's Proposed Exhibit 5. Is that the body of the individual upon whom you did the autopsy?
Yes, it is.
The body is partially clothed in this particular photograph.
Yes.
Is this photograph a fair and accurate depiction of the body as you saw it at the time of the autopsy?
Yes, it is.
I move for the admission of State's number 5, Judge. And for respond, all right, it will be received in evidence then as State's Exhibit 1. I'll make it subject to being connected up. The clerk, Your Honor, that's 5. The court, I'm sorry, Exhibit number 5 is the State's Exhibit 5. Question, Dr. Hollander, in the course of doing an autopsy, did you do an external and an internal examination of the individuals who are the subject of an autopsy?
Yes, I do.
Did you do an external examination on the body depicted in State's Proposed Exhibit or Exhibit number 5?
Yes, I did.
Could you tell us the results of the external examination? And first, let me ask you, if the individual upon whom the surgery was done Was it male or a female?
It was a female.
And her approximate age?
She was approximately in her late 20s.
And did you weigh the body?
Yes.
And what was the weight?
I have the autopsy report here.
Does looking at it refresh your memory?
Yes.
Would you please?
The weight was 125 pounds.
What else did you observe in regard to the, well, perhaps in this case, it would be well to do them both. Let me go a little ahead of myself. Did you also do an internal examination of the body?
Yes, I did.
And what does that consist of?
That consists of making an incision from one shoulder toward the center and from the other shoulder toward the center and down the center of the body, and thus exposing all of the organs within the body. Also, an incision is made from behind one ear across the top of the head to behind the other ear. The scalp is pulled forward and back, a portion of the bone is removed, thus allowing inspection of the brain and the inside of the head.
And did you do that in this case?
Yes, I did.
And with regard to the external examination, is that simply a matter of visually inspecting the exterior of the body?
Yes, inspecting and also measuring anything that needs to be measured.
And did you do that in this particular case?
Yes, I did.
Were there a number of wounds which you observed upon this body?
Yes.
Let's start with the wounds which were not knife wounds, which you found on the top of the head. Could you describe those for us, please?
She had a blunt trauma lacerations, that is tears in the skin on the left side of the head.
Would you point to your own head before we start? I'm sorry. I had asked you before to provide me with a diagram. Do you have that with you now? You have given me two diagrams. Thank you. Let me give one to Ms. Frazier, and I would like the other one marked next in order. Clerk said 69. The court, are they duplicates, or is one the front and one the back?
No, those are duplicates.
Showing you now what has been marked as proposed exhibit number 69. Can you tell us what this represents?
This represents a diagram front and back of the individual that I did the autopsy on, and the injuries are marked on the diagram.
All right. All of the injuries that you located on the body through your internal and external examination.
Yes.
And the copy that Ms. Frazier has, is that the same thing as what has been marked here as 69?
Yes.
Do those marks that you have placed on the front and back portions of those body pictures accurately depict the wounds as you saw them on the body of the individual depicted in State's Exhibit number 5?
Yes, more or less at the location of the wounds, yes.
Does using this particular diagram in conjunction with certain photographs assist you in better describing the injuries to the jury?
Yes.
I would move for its admission, Judge, that is 69. You come in State's Exhibit number 69. Do you have a pen, Doctor?
Yes.
If it's easier, I would provide you with one. What I would like to do is to go through the photographs which I am presenting, holding, and well, let's do this first of all. I want to show you State's proposed exhibits to court. State's Exhibit 69 will be withdrawn from evidence at this time. I'm going to show you State's Exhibits 7, 9, 10, 11, 12, 13, 14, 15, 17, 18, and 19. I would ask that you would look at all of those and tell me if those photographs depict various portions of the body shown in State's proposed exhibit number 5, which was the subject of the autopsy that day.
They do, except for number 15. I can't orient myself as to number 15.
Was there any place on the body of the person upon whom you did the autopsy where there was a single knife wound?
The back.
Okay. Do you see more than one knife wound on the exhibit which you're questioning, which for the record is 15?
No, I just see the one.
Would that be the knife wound to the back?
I can't orient myself with the rest of the portions shown.
The other pictures which I have shown to you, with the exception of 15, they all appear to be familiar to you as showing portions of the body depicted in number 5.
Yes.
Are all of those photographs which I have shown to you fair and accurate representations of the scene of the body at the time you were doing the autopsy?
Yes.
Were you in when those photographs were actually taken?
Yes, I was.
They were taken by Officer Roderick, weren't they?
Yes, they were.
I would move for the admission, Judge. The court, what has been marked as State's Exhibits 7, 9, 10, 11, 12, 13, 14, 17, 18, and 19 may be received in evidence as State's Exhibits as marked. Thank you, Judge. Now I want to refer you back to State's Proposed Exhibit 69, which is a diagram which you have drawn showing the front and back portions of the human form. Was it your testimony before that the wounds depicted in the photographs that have just been emitted are also reflected on the diagram number 69?
Yes.
What I would like to do, if it's possible, Doctor, is to go through the photographs one at a time beginning with Exhibit 7, and I'd like you to tell the jury what the exhibit is, and then mark the number 7 on the diagram wherever is appropriate.
Number 7 shows stab wounds of the top of the head on the right side.
Would you mark a number by the appropriate place on the diagram? You have done that. Thank you. Now I will show you state's proposed exhibit number 8. Could you tell us, I'm sorry, I think that's 9. Would you check on the back of it?
9.
Could you tell us what portion of the body that depicts and why it is relevant?
Number 9 depicts the stab wounds in the back of the neck.
And I failed to do something before. In photograph number 7, how many stab wounds were there at the top of the head?
These are not all clearly shown on the photograph, but there were 8 stab wounds.
Can you, just while you're standing around here right now, can you show on your own head where those stab wounds were located?
They were located in a group on the top of the head and on the right side.
How big of an area do they encompass?
It would be a 2-inch area.
Okay, thank you. Now let's go on to state's proposed, or state's exhibit number 9, which you had indicated were stab wounds in the back of the neck, were they?
Yes.
And how many stab wounds are shown on the back of the neck?
On the photograph, I believe the ruler obscures some. On the photograph, you can see 7, but there were 8.
There were 8?
Yes.
And how large an area would you say?
I guess in a 4 by 2-inch area.
Could you show us on your own neck where specifically that was?
That was in the back of the neck, the lower neck, I guess you could say, on the back.
And the record should reflect that the doctor has written number 9 on diagram 69 to show where those 8 wounds were. Now, before we go on to the next one, were there any other wounds in the head?
Yes, there were the lacerations, blunt trauma lacerations to the right side of the head. These were separate wounds from the stab wounds, which were on top of the head and of a different character. These were lacerations, which means tears of the skin and caused by blunt trauma, not by a sharp object.
So a knife did not cause those.
No.
Those objects or those injuries.
No, it did not.
Now, we'll come back to that later. Were there any other stabbing wounds in the area of the head?
On the right side of the neck in front.
Were there any in the area of the ear?
There was one behind the left ear.
Could you show us, if you could, turn so the jury could see a little bit more, please?
It was approximately here.
Just behind the left ear?
Yes.
Thank you. Well, let's not mark that one. Now, let's take a look at stage proposed exhibit 10. Could you tell us what part of the body that depicts and what wounds are shown there?
Number 10 depicts the front of the neck and the stab wounds on the right side of the front of the neck.
And how many wounds were there?
There were 8.
And how big an area did that encompass?
Over 2.5-inch area.
And I can't recall. Would you show us on your own neck where that was located?
Here, this area.
And would you write, what exhibit was that, 10?
10.
All right. It might help if I could put down which is the top of the picture, because with this decomposition, it's difficult to tell which it is. Could you write on the top of the picture without obscuring any of the wounds?
I don't think it will show with this pen.
Do we have a pen that will mark on photographs? I'm handing you a marker. Would you make a little test pattern on there and see if it works? Doesn't seem to show through very well. Perhaps if you wrote it. Let's go on to the next picture, which is number 11. Can you tell us what part of the body that depicts and what wounds?
That shows the back of the neck, and it shows a stab wound which was obscured on number 9.
So if we combine 9 and 11, we see all 8 stab wounds to the back of the neck. Is that correct?
Yes, yes.
All right, now, if I could show you what has been marked as state's proposed 13, could you tell us what that depicts? Go ahead and tell us what it depicts.
It shows the chest seen from the left side from about halfway down the neck to the waist.
Were there wounds to the left chest area?
Yes.
How many?
Well, they were scattered over a larger area, but there were 8.
Does this picture depict those 8 wounds to the left breast?
Yes, it does.
Okay. If we could mark number 13 then.
The picture was from the neck to the waist. The stab wounds are on the left breast. Some of the ones on the right breast are visible.
But not all of them.
No.
Okay. If you would write the number 13 then, near where it depicts them on your exhibit 69. Now let me show you state's exhibit number 12. What does that depict?
Number 12 shows the front of the chest from the neck to below the waist, and it's from the right side, so you can see the stab wounds of the right breast and a few of the stab wounds of the left breast.
But not all of them.
Not all of the left breast, but all of the right breast.
How many stab wounds were there on the right breast?
8.
If you would write in the number 12 in the appropriate place on the exhibit 69, please. And then let me show you state's proposed exhibit 14. Could you tell us what that depicts and what wounds it shows?
14 shows the lower portion of the trunk from a little bit above the waist to the genitalia, and it shows 2 of the stab wounds.
Could you then draw a circle on exhibit 69, encircling the 2 stab wounds that it does show, and then write the number 14 within that? Thank you. You said that it showed 2 of the 3 wounds to the stomach. Do any of the other photographs show the 3rd one?
I don't think so.
All right. Where was it located? In fact, if you could stand and show where those 3 wounds are located on your own body, please.
Well, there were a total of 4 wounds to the abdomen area.
What is the 4th one?
There was one which was near above the waistline, which is one that went into the liver. There were 2 on the left side of the abdomen, which are depicted in this photo, and there was one to the left side of the genitalia, which is not seen in this photo.
Let me show you now state's proposed exhibit 17. If you can tell us what that depicts.
Yes, it shows the cut on the left upper arm.
And you have marked that on diagram 69.
Yes.
And now if I could show you exhibit 18 proposed, what does that depict?
That was a cut on the back of the right hand.
Is that shown on 69 as well?
Yes,
Would you place that on there? And the number is 18 you're placing it on.
18.
And the last photograph is number 19. Would you tell us what that depicts?
This shows the scrapes and abrasions on the back of the second and third fingers of the left hand.
Do they have nothing to do with knife wounds?
That's right.
Okay. If you would mark that, please, putting in number 19 by that one on 69. Now, if we could go back to 69 for a moment, do the additional numbers that you have added to that diagram correlate the applicable pictures to the diagram so that one can go from the diagram 69 to the photographs and understand which each refers to?
Yes.
And are those numbers fairly and accurately represented in the photographs represented by the numbers on the diagram 69?
Yes. Not all the injuries are seen in the photographs.
I understand. Some of the injuries have not been shown in photographs.
Yes.
I would move now for the admission of 69, Judge. The court may now be received into evidence as states exhibit number 69. Let me work backwards now, if I can, Dr. Hollander. There were 2 knife wounds to the arms or hand, one on the arm and one to the left hand, or the right hand area.
There were 2 cuts in the left upper arm. The photograph shows only one of them.
I see. And then there was the cut on the right hand.
Yes.
Do you have a characterization for those kinds of wounds?
A cut, as distinguished from a stab wound, is longer on the skin surface than it is deep. The stab wound is deeper than it is long on the skin surface.
Are you familiar with the term defensive wounds?
Yes.
Does that term apply to either of those?
Yes, the term can apply to both the hand and the arm wound.
Could you describe what you mean to the jury?
The defensive wounds are wounds which are sustained in an attempt to ward off a knife or other instrument by the person being stabbed, and it usually is located on the arms or hands.
Could you tell me what your internal examination disclosed that's of major importance in this particular case with reference to any of these knife wounds?
Yes, the knife wounds in the front of the neck penetrated into the muscles of the neck, and one penetrated to between the 3rd and the 4th cervical vertebra, going in between the 2 and reaching the spinal cord, causing a hemorrhage. The stab wounds of the chest on both sides penetrated into the lungs. There was also one stab wound in the back, which penetrated into the lung from the back. The stab wound of the upper abdomen penetrated into the liver. Those were the major internal injuries. The other stab wounds penetrated into muscles, which caused hemorrhage, but did not penetrate into any vital organs. For instance, all the stab wounds on the back of the neck and the top of the head only penetrated the skin, did not go into the head.
The information about the wounds, both external and internal, that you have given to us, was that information sufficient for you to render an opinion as to the cause of death of this individual?
Yes.
And what was the cause of, please? Cause of death, please.
The cause of death was multiple stab wounds of the neck, the chest, the back.
Could any of those alone, or did all of them together cause the death?
All of them together caused the death.
Was the cause of death homicidal in nature, in your opinion?
Yes.
Would you exclude accident
Yes.
or self-infliction?
Yes, I would.
Were you able at all to make a determination as to the order of the wounds, in which order they were received by the individual?
No, these were numbered for the purpose of convenience, and the numbering which we used in our report does not reflect what order they were received in. It's really not possible to tell what order these wounds were inflicted.
Can you tell us what the effect would have been upon the individual receiving these wounds at the time they were received, insofar as allowing her to continue to move around? Were there any of them, for example, which were completely incapacitating?
There was one wound which would be incapacitating, and that is the one that reached the spinal cord. The wounds to the chest penetrating the lungs would certainly have not been immediately fatal, but they would have certainly been incapacitating.
When you say incapacitating, does that mean that the person receiving it would not be able to be up on her feet and moving about?
She might move about, but not very purposefully.
More in a thrashing, reactionary manner?
Yes.
What kind of force would it take to thrust a knife into the body in the manner in which it was done here?
The stab wounds were through soft tissue, skin and soft tissue. They were not through bone, so the force would be moderate, but not excessive.
Were any body fluids retained so as to allow toxicology exams?
Yes, there was decomposing fluid in the right chest, which was sent for toxicology.
And do you have the results of the toxicology exam?
Yes.
How are toxicology exams done?
Blood or body fluid is obtained by me at the autopsy and sent to a laboratory for toxicological test examination.
And is that a laboratory with whom you work on a regular basis?
Yes, it is. It's the only laboratory we work with, and they send a report on the results.
And do you send body fluids whenever possible from your autopsies to the toxicological department so that they can perform their exams?
Whenever it's necessary, yes.
And it was necessary in this particular case?
Yes.
And do you always receive results back from them?
Yes.
Do you know of any instances in which those results were not correct?
I think there were one or two in which case we called because the results were not reasonable and it was a misprint.
Just a misprint
Yes.
on the piece of paper?
Yes.
And that's over the, I can't remember what you said, 2,000 or 3,000 autopsies that you had to do with?
Well, this is here in Clark County.
How many autopsies would that include?
They do all the work for this medical examiner department, which would include possibly over 1,000 cases a year.
And there have only been a couple of misprints over that period of time?
That I know of, yes.
And just in 1 year, not to mention all the other years that it goes on. Are these reports upon which you rely in order to do your pathology work?
Yes, we rely on them sometimes to make a diagnosis.
What was the level of blood alcohol which was found in the blood of the person depicted in State's Exhibit 5 as a result of the toxicological examination?
The level of alcohol was 0.09 grams %, and this was in the decomposed fluid in the chest.
Does the decomposition have anything to do with the level of blood alcohol?
Yes, it can.
To what extent?
It can increase because of the bacterial decomposition. It can increase a blood alcohol level.
Do you know by what percentage?
No, it varies.
Have you been schooled in that area?
Yes, I have testified many times on that area.
You heard the judge's concern, hypothetically, if this body had been in its decomposed state for 10 days. Well, now let me ask that question and then we'll get back to this one. Do you have an opinion as to how long this body had been decomposing? When it had died prior to the 30th when you did your autopsy?
I was given the information that she was last seen on the 19th of the month, and the amount of decomposition of the body is consistent with that length of time.
So is that a 10-day period that you're talking about?
10 days.
She was found on the 29th.
Yes.
So now back to my question.
Excuse me, she was found on the 30th.
Just after midnight on the 30th.
She was pronounced dead on September 30 at 2:30 a.m.
Okay. Given the fact that the body had been decomposing for 10 days and had been dead for that period of time, would that have any impact at all upon the level of blood alcohol that she had in her system at the time of her death?
Yes. Let me just say that the level of alcohol doesn't change after death, except for changes in decompositional changes. In my experience, the level of alcohol can increase by 0.02. It's 0.02 and she had 0.09. So it is possible that she had a lesser amount of alcohol.
If my mathematics are correct, then she would have been at a 0.07 to a 0.09 at the time of her death.
This is in my experience, depending on the amount of decomposition or depending on whom you read, the values can differ.
Could she have been at a level higher than .09 at the time of her death?
No.
But a level lower, not to be lower than .07, is that a fair statement?
She could have been lower, yes.
Then a .09?
Lower than a .09 and possibly even lower than a .07.
Now, is it within the realm of your education experience in schooling that you are able to tell us anything about how many drinks the size of the person depicted in the Stacy's Exhibit 5 would ingest to get her to a level of .07 to .09?
Yes, there's a formula which will give us the number of drinks.
Okay, could you utilize that formula and tell us, first of all, let's take .09. Can you tell us a number of drinks that this person would have ingested in order to raise her blood alcohol to a .09?
The weight of this person was 125 pounds. For a 125-pound person to have a level of .09, she would have had to ingest 3 to 4 drinks of alcohol in the hour prior to her death.
And would that change at all for the .07 group?
That would be less. It would be 2 to 3, but also the weight of 125 is with decompositional changes. It is possible that she weighed somewhat more before she decomposed.
Are we in the ballpark if we say that she had ingested 2 to 4 drinks in the hour prior to her death?
Yes.
Now, referring you back to the toxicological report, does that report do a drug screen to determine whether or not a person has any drugs in their system?
Yes, it does.
And what was the result of that particular part of the toxicological report?
There were no other drugs identified in the blood other than the alcohol.
Let me break the question down a little bit, Doctor. You told us that there were, can you tell me if my arithmetic is wrong, but 45 knife wounds, is that correct?
Yes.
And there were, by your testimony, 5 groups of 8 wounds in fairly small clusters, is that correct?
Yes.
Let me show you what we've marked as state's proposed 67A. You've never seen this knife before, have you?
No.
Can you tell us, did you make measurements of all the wounds?
Yes, I made measurements of the wounds. The actual wounds varied between 3/8 of an inch and ½ an inch. Most of them were 3/8 of an inch in length.
The length of the wound?
The length of the wound on the skin surface.
Are you able to tell from looking at the wounds as to whether or not the knife used was a single-edged or a double-edged knife?
Yes, the wounds showed that the instrument had a single sharp edge.
How do you determine that?
By looking.
Well, what does the wound look like when a single sharp edge is used as opposed to a double sharp edge?
One end of the wound will come to a point when looked at in a magnifying glass. With a double-edged instrument, both ends of the wound would be sharp.
All right.
Here, there was only one end of the wound that was sharp.
So all the wounds then were done by a single-edged blade?
Yes.
And what about the measurements of the depth of the knife wounds? Were you able to make those computations?
The depth was about 2½ inches. The deepest wounds were 2½ inches. That is in the liver, lung, and the one that went between the vertebrae, the one that went in the back.
So we're looking at 3/8 of an inch to ½ an inch wide and up to 2½ inches deep. Did you say?
Yes.
All right. Would you take this ruler and use it with this knife and tell us whether or not that particular knife, the blade, would be consistent with the wounds which you observed on the body?
The length of the sharp portion of the knife is 3¼ inches. It varies in width, with the widest portion being 3/4 of an inch and at 2½ inches. The widest portion is 3/4 of an inch.
Does the skin have any elasticity when a knife is placed into it,
Yes, it does. It tends to spring back after the knife is removed.
making the wounds that you would measure smaller than the actual entry wound, the entry measurement at the time that the knife was plunged in?
Yes.
Okay. Can you tell us then whether or not the knife which is shown in proposed 69A could be consistent with the wounds which you observed on the body of the person shown in the exhibit number 5?
I don't think so. I think it would have to be a smaller knife.
Doctor, yesterday the last thing that happened was that you looked at the large knife which was number, court said 67A? 67A, okay, and have told us that the size as far as width and measurements were concerned was not consistent with the wounds of the deceased in this case, is that correct?
That's correct.
Now let me show you what has been marked as State's Proposed Exhibit 74A. And have you ever seen this particular knife before?
No.
And we have to remove the tape. open it for you. It appears to be 2 blades, so I'll leave them both open. May I have the rulers on this? And would you again, as you did yesterday, measure the dimensions of those 2 blades within the knife and tell us if they would be consistent with the size of the wounds that were located on the individual shown in State's Exhibit 5?
One of the blades measures 1 5/8 inch
In length?
in length and 3/8 of an inch in width, and it has one side which may be sharp. It's not very sharp. The other blade measures 2 1/8 inches in length and about 3/8 of an inch in width, and has one side that should be sharp. It's not very sharp.
What would be your opinion as to whether or not either of the blades of this knife are consistent with the wounds found in the deceased?
I think it's possible, but not too likely. The wounds were up to 2 1/2 inches in depth and between 3/8 and 1/2 inch in width, and I did not see any hilt mark externally, which would probably be present if this knife went in.
What is a hilt mark?
If the knife goes in completely up to the hilt, there would be an external mark showing, so to speak, the dull base of the knife.
Is that in all instances or just when it's pushed in hard?
If the knife went in all the way, and this is the whole length of the knife up to the hilt, then there would be a hilt mark, and I did not see it.
So then your testimony would be that the knife we just looked at, 67A, I think, may not be consistent. Phone number. Was that 74A, Ms. Clerk? The clerk says the small knife, yes, 74A. So let me rephrase that. The knife that you just looked at, 74A, may be consistent with the wounds, but probably not.
That's correct.
Let me ask you a little bit about the head wounds that you had spoken of before. How many did you say there were?
There were 3 blunt trauma lacerations, and then there was the group of 8 stab wounds to the top of the head.
It's the blunt trauma lacerations that I have in mind. Where on the head were they located?
They were on the right side of the head, above the forehead.
Would you tell the jury the force required to inflict these kinds of wounds?
You need a fair amount of force because it's the blunt trauma that breaks the skin, and that does require force. For instance, if you stand up under a cabinet and hit your head, you don't usually tear the skin. You might get a black and blue mark, but you don't tear the skin, so that when the skin is torn, there's greater force.
And you are not able to tell us the instrument that caused those wounds, are you?
No, there's no pattern there.
Can you tell us whether those particular blunt force trauma wounds occurred before or after, or at the same time as the knife wounds found throughout the body?
At the stage of decomposition that she was in, I could not say. It would seem likely that they occurred before the knife wounds.
Why do you say that?
I can't imagine someone sitting still for 8 knife wounds to the top of the head.
Let me ask you in relation to that. Let's assume hypothetically that the blunt force trauma wounds to the head being hit over the head was the first thing of all the wounds that you saw on this body that occurred. What sort of an effect would that have on the person receiving it?
I think it might incapacitate them temporarily.
What do you mean when you say incapacitate them temporarily?
Make a person dizzy, perhaps, and not necessarily lose consciousness, but just make them unable to move temporarily.
And for how long a period of time would you place on the word temporarily?
I think it may be between seconds and minutes.
It could be as long as a minute.
Yes.
This would be short of rendering a person unconscious, but not allowing them the ability to move as they normally would.
Yes, I think so.
Thank you. I have no further questions.
We're going to read the cross-examination, Mr. Erickson.
Yes, sir. Dr. Hollander, you can't really say that those wounds wouldn't have rendered a person unconscious, can you?
No.
I'm talking about the lacerations to the head.
There was no fracture. There was no hemorrhage within the head, so that they were certainly short of being very severe wounds.
Would you say it was moderate trauma?
Yes.
But you can't say, looking at a body at the stage you looked at it, whether or not a person would have been knocked unconscious by this blunt trauma. Is that right?
That's correct.
Now, you stated that it would not be inconsistent that death had occurred on September 19th. Death could have occurred up to several days later than that. Is that correct?
Yes.
You did the autopsy on what date?
I did the autopsy on September 30.
What would you say the latest possible date was that death could have occurred on that body?
I could not estimate. There was a considerable amount of decomposition, and at that stage, it would depend on temperature, on a number of factors, how long this had been, so you really have to figure out from other information how long she had been dead.
Did you ever make an estimate from other information? Or did you just go by what you had heard about when the probable date of death was?
I didn't make an estimate.
Now, you stated that a fair amount of force would have been used to inflict the blunt trauma to the head. Would it be correct to say that would it be correct to say that the heavier the instrument that was used, the less force that would be required by the person using it?
I don't really think you can say that.
If a person were using a smaller instrument, one that wasn't quite as heavy, it wouldn't take more force to break the skin than if a person was using a very heavy instrument.
Like, for instance, a small hammer versus a large hammer?
Let's say that.
There was no evidence that it was a hammer because there was no pattern.
Right. There was no way to tell what the instrument was, is that right?
That's right.
What I'm asking you is, yes, let's use your example. There's no evidence it was a hammer, and you can say that it probably wasn't. But let's say that it was. If you had a bigger hammer, wouldn't it take less force in order to break the skin than if you had a smaller one? Wouldn't you have to hit harder with a smaller instrument in order to do that?
It depends what you wanted the end point to be. I don't think a person usually controls the force.
You can't look at the wounds, the blunt trauma, and the stab wounds and tell anything about the assailant, can you? Or can't you?
No.
For instance, you can tell what, for instance, can you tell what sex the assailant was?
No, I'm just describing the wounds on the victim.
I understand. I'm asking you, could you tell that? Could you tell the sex of the assailant?
No.
Could you tell the size of the assailant?
No.
There's nothing about the wounds that would indicate to you how tall the person may have been or anything like that.
No.
Now, you indicated on direct examination that there was some wounds on the victim's hands and arms that you stated could be defensive wounds. Is that correct?
They are defensive wounds.
And you say that because of the placement of the wounds, is that correct?
Yes.
Because of where they are on the body and because they are cuts instead of stabs?
Because of where they are on the body, which means that the victim was trying to ward off the assailant.
Now, that's a conclusion that you have reached. Is that correct?
That's what we mean by defensive wounds.
There was a lot of testimony yesterday regarding the alcohol level in the body that you did the autopsy on, and you indicated that, if I'm stating your testimony correctly, that it could be that the alcohol level was consistent with this person having had 2 to 4 drinks in the hour before she died. Is that correct?
That's the level, and according to the formula, wait.
Now, in a living body, as alcohol is metabolized, the rate goes down. Isn't that correct? If you have a drink right afterwards, the alcohol level will be higher than several hours later. Is that correct?
That's correct. At death, however, all metabolism stops.
I understand that. I'm talking about a living body. Is that right?
Yes.
So if she had consumed more than 2 to 4 drinks, if she had consumed 5 or 6 or 7 or 8 drinks earlier in the evening, then her body could have metabolized the alcohol down to the point where it was at the time of her death, if it had been several hours later. Is that correct?
That's correct. That's a matter of calculating the amount.
So you can't really say how many drinks she had that night, can you?
No, I'm simply stating for comparison purposes what this signifies, what this level signifies in terms of numbers that people ordinarily understand.
Well, what I'm asking is if she consumed those drinks in the last hour of her life, you would know how many drinks she had had. But if she consumed them earlier, there's no way of really telling how much alcohol her body may have had. Is that correct?
That's correct.
I have no further questions.
Just briefly, so I understand what the level of blood alcohol signifies, are we talking about what it signifies at the moment of her death? That is the blood alcohol level of 0.072, 0.09 that you referred to yesterday, is what her blood alcohol level was at the moment of her death.
Yes, it could not have been more. It may have been less, and then a certain amount was due to bacterial activity.
And so while we can't, as Ms. Frazier points out, we can't know whether or not the alcohol came from a lot more alcohol, a lot earlier in the evening, she was operating and functioning under a .072, .09 blood alcohol level
That's correct.
when she died.
Yes.
Thank you, I have nothing further. That concludes testimony.
All right, thank you. This is a good time for us to take our break. As always, remember, do not talk to each other about the case or about anyone that has anything to do with it. Do not talk with anyone else about this case or about anyone that has anything to do with it. Do not let anyone talk to you about the case or about anyone that has anything to do with it. If someone should try to talk to you, please report to me immediately by contacting Marshall. Do not read any news stories or articles or listen to any radio or television reports of the case or about anyone who has anything to do with it. Do not visit the scene of any of the events mentioned during the case or undertake any investigation, experimentation, or research on your own, including the use of social media to in any way discuss the case or the use of the internet or reference materials to investigate or research the matter. And do not begin to form or express any opinion on this subject connected with this case until it's finally submitted to you. All right, thank you for your attention here. We'll get back in action here in just a little bit.
All right, you're ready?
Okay. So do you have anything left other than us resolving the outstanding objections to your transcripts and I think the autopsy report?
I don't recall there being one for the autopsy report, but no. I mean, once you resolve the, depending on what your ruling is, I mean, if you made a ruling that certain things, you might have something more tomorrow, but otherwise, assuming what your rulings are going to be consistent with what you've made before, we should be done.
All right, let's take a, I need to run to the restroom. Let's take a restroom break and then we'll come back and real quick discuss your objections to the outstanding exhibits. All right.
You know, in addition to the previous objections we had to the introduction of these transcripts, we would now add the objection that with the state having put Detective Vaccaro on, and he summarized all of this evidence and went through all of the central allegations of the crime from the guilt phase, that now adding these transcripts of these witnesses that they could have presented or read in transcripts is duplicative, and certainly goes against the purpose, as we understood it, of allowing Vaccaro to testify over our objection on the hearsay issues.
I think we did the autopsy, but that was just the general objection. Like, was that introduced at the first time, the autopsy report?
The report itself was not introduced,
Okay, then we objected.
but that was already been admitted. It was the PSI that is still outstanding.
Oh, okay. Well, the PSI, I think should.
And, you know, we would object to the PSI that has been proposed. I think that's from the first, or,
83, 84.
yeah, from the robbery conviction aggravator that they're seeking. And obviously, a bunch of information has already been presented. The testimony of Mr. Henderson was read. The judgments of convictions have been entered in, and what we think that this information is duplicative and certainly hearsay and goes beyond what is necessary for the purposes of this penalty phase hearing.
Okay. Focusing on the PSI first, is there anything in particular in the PSI that you feel is of such questionable trustworthiness in and of itself that I should be focusing on? I mean, otherwise I am going to be tending to let it in, but I'm looking at if there's something in particular that you feel is a particular issue, you can always redact that.
May I look at that copy? I certainly have that in all of my discovery. I've seen it, but I don't have it.
Sure, go ahead. Again, it's the same thing. I don't think I've introduced State 61, which is the police report of
No, you've never made a ruling.
on Officer Hildebrand. So again, I'm based on my research, and, I think the state can introduce it. As far as the issue in terms of cumulative, I mean, there are obviously things that are cumulative, but that doesn't necessarily mean that it's not admissible in that, cumulative can also have some impact in terms of credibility. So I'm not inclined to do it, but if there is anything in the police report, again, that you feel is particular, I forget what the term was in the state Supreme Court.
Suspect or highly impalpable.
Yeah.
Or is
Suspect.
it highly suspect or and impalpable?
Yeah, impalpable. I'm more than willing to look at any particular spot.
Your Honor, in particular on that, it would be any references to statements that Mr. Valerio made allegedly to the investigating officer. It's my understanding that does include
Well, I mean, that would
allegations.
be in particular of, relevant. There's nothing to suggest the officer, beyond the fact that it's hearsay and not available for going through the cross-examination process. There's nothing to indicate that it's speculative or palatable. So, I would deny a motion on that basis. Anything in terms of the PSI?
Yes, Your Honor, you look at certain sections of it. The issue of the plea bargaining section in there. That, and then there is alleged a warrant out there that there is no conviction, nothing on, just that there's a warrant. And then the conclusion in here, the evaluation is inappropriate, because that is someone else's evaluation, and that's an evaluation.
I would generally concur with those, with redacting those 3 points in the statement.
Well, as an exception of the warrant, which I don't know what I just did with it, I brought the detainer when he goes to prison, Arizona, and he resolves his detainer in Arizona. Arizona gets notified, there's a warrant outstanding for him, and the back page shows his conviction for that crime according to the Department of Justice, as well as the combination of the PSI. And he gets this warrant in Arizona before coming here and attacking Mr. Henderson. That is clearly relevant to sentencing. I don't care about the striking of, that there was a plea bargain or that the conclusion of the PSI writer, that's fine, but
All right, so you're saying there was a resolution to the warrant in there?
No, it was dismissed.
It was dismissed.
one was dismissed, one convicted of. He has 3 separate warrants at the time, Judge.
Well, it says Arizona, and I don't think the Bureau of Justice thing, because it says misconduct of a weapon, no formal charge. So,
Keep going.
What have you done?
There's these 3 Arizona entries, all of which are subject to the detainer.
I don't know, you're on my shoulder, but that's okay, come on back.
No, it's all right.
Possession concealed to face decline, so that's gone. And then theft of misdemeanor, possession of stolen property, we know nothing about it. There's been no certified copy of any conviction of that or any basing on it. And then the police on Valerio, Page, Arizona, says theft felony, but then convicted. It looks like it was a misdemeanor.
Right, he just convicted of a misdemeanor.
But you have to bring something in to show that you haven't. Since when? Since now.
Is it suspect or highly palpable?
Yeah, well, it's suspect when, without anything there. I believe police, they the robbery is our case. So, those are my,
I mean, so the first 2, where there's no resolution, I'm good with striking any reference to that. But I mean, the one where is there a reasonable record, criminal history that shows the misdemeanor conviction on the 3rd warrant?
Yes, it's the DOJ's record, it shows that he was convicted on 9/1/83, guilty of a fine, and the resolution from the 8/3/83 one, I actually think that those are the same police department. I think those two are the same one, and then the one before is the one that's dismissed.
Oh, boy, I haven't seen these things from the Department of Justice in years.
Yeah, since about the mid-90s.
Yeah,
Never mind.
so the convicted on the 8/31/83, is that what you're saying?
Yeah, he has a conviction on 9/1/83.
9/1/83.
And he is a fugitive from justice at the time he's arrested, and I have the detainer here for that.
Okay.
And we should at least be entitled to argue that he's a fugitive from justice at the time he commits the crime against Mr. Henderson. That would be highly relevant to sentencing.
That was all we know about it was dismissed.
Either way,
Right.
The detainer was the detainer for the crime that's charged in, where there's a conviction on 9/1/83?
I've never seen the detainer judge, so I don't think we can respond, which I think creates the problem of putting in something like that. And, you know as well as I do that when you object to that, they have to come forward with it. I've never seen a detainer.
yeah, there's a detainer right here, it's part of the discovery, and it has all the teletype
But where's the
speakers.
part where it's dismissed?
Well, it's in there.
It's drunk.
That one crime was
What is this?
dismissed.
Hold on, one at a time.
All I'm saying is that these are not the things that should be introduced. Now, you're looking at the federal rap sheet?
Right.
Okay, well, you can read it as well as I can.
Right.
Well, all right, so I'm sitting here, and all right, so what do you have? This shows no formal charge as to
The weapons charge.
the, let's refer to the arrest date. No formal charges as to the 3/27/83, and then no charges or disposition to the 8/03/83, and then it shows convicted, fine, on the 8/31/83 arrest.
Well, based on the way I read these, Judge, that is the last two are the same ones. The theft, possession of stolen property, and then convicted of theft, both out of the police department, Arizona. That's the same event, I think they just put it in twice. You know, like you see those in NCIC, you get a double entry. My understanding is that he had the misconduct involving a weapon, which got no formal charges, possession of defaced weapon and minor possession of alcohol, which prosecution was declined. Then he has a detainer for theft of credit card, fugitive, Flagstaff, Arizona, and then there's the teletypes back and forth saying they can come pick him up. And ultimately, he is convicted of a misdemeanor and given county time for it.
All right, what do you have in terms of, showing?
The detainer is for theft of credit card out of Flagstaff. And the warrant was entered prior to him being taken into custody in Nevada.
What was the warrant for?
The warrant is for theft of credit card, which is his 8/31/83 conviction that shows a 9/1/83 conviction. And then,
Do you have the detainer information that he's talking about here?
yes,
The detainer information doesn't go to the facts of the case.
No, I mean, what he's saying is that he came here, essentially a fugitive from justice.
No,
He committed a
no,
crime.
what a detainer would show is someone that may be here, if they put it out, someone may place a detainer on it. But the fact that there's a detainer doesn't mean you're a fugitive from anything. It just means it's a hold.
Yeah, it's a hold. I mean,
That's
usually
all
it
it
means
is.
that you went away from where you had an outstanding warrant. I mean,
No, I mean, we do it quite, we do it for Las Vegas City.
The PSI says the has an outstanding warrant out of Arizona. We have the detainer placed from that warrant in the PSI as a detainer for theft of credit card, and his federal rap sheet shows he was convicted in 9/1 of '83, and when he's arrested, a warrant from Arizona, I'm assuming because he was in custody and never checked back in,
where do you see the warrant? It makes reference to a warrant.
in the PSI, they just wanted that redacted. I could jump back to it, but I believe it's probably in the conclusion where they talk about he has an outstanding warrant for. But I have the detainer that's placed here.
Say where it makes reference to the warrant.
It's retarded.
I don't have it in front of me, so I get it back to whatever.
The agency also reported the issuance of a felony failure to appear warrant relative to the charge of credit card Judge Grayson. Okay. Well, we'll redact from the Department of Justice rap sheet the references to the 3/27/83 arrest and charges. I'll keep the other ones in terms of the PSI. Strike again the 3/27 arrest information concerning the charge, and on page 3 of the pre-sentence investigation report, we'll strike the plea bargain and the evaluation on page 6, and the plea bargain also on page 3.
Okay.
That'll be the order of the court in reference to that. All right.
Just clarification on what is being left of the Arizona charges. Is it clear on there that he was pled to or convicted of a misdemeanor? 'Cause I didn't
It's
see
a
it.
$34 fine.
Yeah, okay.
But up above, does it say felony? I'm just wondering if we need some type of verification that this was a misdemeanor.
It says agency also reported issuance of a felony failure to appear. And out of Encino County in Arizona. They placed the detainer. They obviously pled it down from a felony.
Right, and I think that we all know that because of that fine, but I don't know that the jury would know that, because it says felony on there, so we would want
All right.
some type of,
If you, I'll let you, we'll just have it to where the agency also reported issuance of a failure to appear warrant relative to the charge of theft of a credit card. We'll strike in the felony reference. All right. That begins with page 3. Do you have an extra copy for, all right. Okay, well, I need you to redact this one according to my orders. Let's get the jury in here though, and we can work that out after we get the jury gone for the day. So I'm going to omit the transcripts of the prior testimony. We'll omit the exhibit 80 as redacted, and we'll omit state 61. All right, with that, what is the state's situation?
Well, based upon this sort of discussion, I'd like to run a fresh NCIC on before I arrest him. Because I could always put the fresh NCIC in if there is some change that situation. So
Alright.
we'll rest in the morning, but I don't anticipate there being any other evidence.
Okay, I'm gonna tell the jury that you're about at the end of your case, that you may rest, but you wanted to check on something. We'll finish up your case and we'll get started with defense tomorrow.
The only thing is that Dr. Coates would be in tomorrow afternoon.
Okay?
So I don't know how long, depending on what they do, depending on what we do.
Well, I'm gonna guess that we're gonna get started about 10 o'clock tomorrow.
Oh, 10, okay. All right, then I think that'll solve
You
the
think
problem.
that'll solve the problem?
Sure.
Yeah, we'll get
I'll
started.
try to have them here. What do you think, I'd break, you'd be at lunch?
Well, I usually like to go, I'll break whatever time to make it work.
No, I
usually
want to tell him to call him today.
Well, do you have enough people to go from 10 to 12:30?
Do you?
Yes, we should. We have
Right.
Mr. Hatcher and then a number of family members.
Okay, I generally like to go until 12:30 to 12:45, because that gets them past the lunch crowd downstairs, so.
We may have to address something outside the presence. Maybe we should let the jurywoman address it now as it relates to Case Stevens, but other than that, the
Case Steve, okay.
the minister,
All right, yeah.
the lady.
So I'll just tell Dr. Coates to be here approximately 2 o'clock, and that should get
Okay,
us there. Okay,
That you, right down?
okay.
all right, yeah, 2 o'clock or 1:45. And I don't have any problem, if we need to make some, interrupt
Right,
somebody
that-
else's
that-
testimony.
That was all I did.
Okay, all right, let's get the jury in here.
And the court is aware of Dr. Reutemann, then he can't be here on Thursday.
Okay. Put Royman on Thursday afternoon.
I catch a plane at 5:15. I'm running out the door. And I measure right to take that.
Mr. Pesci is more than competent to hold up the
Yeah, I will
state's,
now.
We've been fighting over who gets to cross it.
Yep, it will, not really hard.
What?
It will now.
Won't take that long.
See, all right, yeah.
Oh, yeah, see. You don't want to try and get off the one conversation. The last experience wasn't that fun.
Yeah, we'll see.
We might just bring Stanton in again, because man, did he get mad at Stanton.
That one gets mad. That one gets mad at you.
On Randy.
Except maybe.
Him and Stanton.
All right, jury entering.
That wasn't that anymore.
That's everyone, Your Honor.
okay, let the record reflect the presence of the attorneys for both sides, the presence of the defendant, should the parties stipulate the presence of the jury.
Yes, Your Honor.
Yes, Your Honor.
Okay. I feel bad having everybody sit down because we're going to let you go here in just a minute. The state has indicated that it's close, if not done, with the presentation of its evidence. They wanted to check a couple things tonight to make sure that there wasn't something that they were missing. And so I said I'd let them do that, and they can, assuming that there isn't, they'll rest first thing in the morning when we get back together. We'll get back together tomorrow at 10 o'clock. So if you can be here at about 9:50, we'll get started at 10 o'clock. And my guess is we'll get started with the defense case. I've been told that the defense does intend to present some witnesses, so we'll get started with the defense case at 10, and we'll go tomorrow and then go into Thursday and see where we're at. So that's going to be sort of the plan for the next couple days. Until we meet again tomorrow, I'll give you the long version. Do not talk to each other about the case or about anyone that has anything to do with it until the end of the case when you go to the jury room to decide on your verdict. Do not talk with anyone else about this case or about anyone that has anything to do with it until the trial is ended and you have been discharged as jurors. Anyone else includes members of your family and your friends. You may tell them that you are a juror in a criminal case, but don't tell them anything else about it until after you've been discharged by me. Do not let anyone talk to you about the case or about anyone who has anything to do with it. If someone should try to talk to you, please report it to me immediately by contacting the marshal. Do not read any news stories or articles or listen to any radio or television reports about the case or about anyone who has anything to do with it. Do not visit the scene of any events mentioned during the case or undertake any investigation, experimentation, or research on your own. This includes the use of any social media to discuss the case or the use of the internet or any reference material to do any sort of investigation or research, and do not begin to form or express any opinion on any subject connected with this case until its file is submitted to you. So we've made some good progress today. Again, I appreciate everybody's patience. Ms. Johnson, I know I asked you to be prepared to stay a little bit late. I assume you did that, and I want to thank you for making those steps, but to be able to get home to the family on time today. So thank you, though, for your efforts in that regard. Everybody, thanks for the day. We'll see you tomorrow. Have a good one.
All right, you're acting.
Just you highlighting for yellow for me, what I need to redact, that'd be great. 'Cause
Yeah,
I believe
I've
it's
just
exactly
marked
true.
out what I'm thinking, so if you got an issue, or we'll show it to counsel, Mr. Erickson, Mr. Vaccaro, and if there's something I'm missing or there's an issue, it was interesting to see who prosecuted this.
Peggy Lee was the prosecutor at the preliminary hearing.
Okay.
Sorry. I don't think they put our names on it back then. Oh, Robert Thompson is the public defender, Bruce Dickinson is the deputy district attorney.
All right. Your state's.
That's your copy.
That's my copy. Thank you. All right. Lucky me.
That's the original.
All right. Let's see, what else we have to do?
We need to address the issue of Kay Stevens before she comes in tomorrow, testifies.
Oh, yeah, who is it? What are you talking about?
Well, it's my belief that Kay Stevens, based upon our research, is a capital punishment abolitionist who began her relationship because Mr. Valerio was on death row. And they said they're going to bring her in here to talk about how they're friends. Apparently, she's friends with a lot of people who are on death row, and certainly her bias is going to be highly relevant to cross-examination. It's something that Lovato says we're entitled to get into. And so I just want some direction from the court, considering the court's ruling saying, don't go near this unless you bring it to my attention. If I'm mistaken and this is a different case, Stevens, and our research has shown, but I believe based upon just even what Mr. Vaccaro says, that this is the same individual.
All right, so where are you wanting to go?
We'll cross-run our bias.
Okay, well, yeah, I don't necessarily, I guess, why don't you give me just a thumbnail as what you're planning on doing, and that way I know I'll turn to them and say, what issues do you have with what Mr. talking about?
Well, the part that most concerns me is the reason she started the relationship with Mr. Valerio. How is it that you identified Mr. Valerio as a person to have this type of relationship with? Well, because he was one of the people on death row, and I'm unclear right now whether or not she found him from the websites that are out there for death row inmates to find abolitionists. But my main concern is that whichever way I think of this in my mind of going about, you're an abolitionist, you don't believe in this, you reached out, you started the relationship with Mr. Valerio, and how is it you found Mr. Valerio? The answer every time leads me back to, I can't think of a way to get there where I get to bring out that this is a manufactured relationship, manufactured around the fact that he's a death row inmate. I don't know how it is I can bring out that situation and her biases in coming in here to say, oh, he's a lovely individual. Yeah, you think about that about every murderer that's on death row. And I don't know, everywhere I turn, I get to the point where it's going to come out.
The issue is referencing to death row.
Correct, that's the issue for me, is that the court told me not to go there, we were
I
able to limit
appreciate
it
that.
for Hatcher, we were able there to limit it, but I just don't know how the answer is gonna come out. Unless I'm wrong and there's some other reason that they have this relationship, but based upon my research, it's my belief that their relationship started because Mr. Valerio was on death row, and that she routinely
Can we
befriended
say that
people.
he was that she has this relationship with people who are death penalty eligible?
Why can't you just say like the anomaly these things are is that she's involved in, you don't have to use the word prison ministry, but, you can,
Being a death row abolitionist is
I don't know what
different than
death row
prison
abolitionist is.
is.
is what? I mean, how does that reflect
I mean, anti-death penalty, and I mean, someone who goes to the nth degree to try to defeat the death penalty for anyone.
Well, having
I'm not
been-
saying that that's bad or wrong, but I mean, it goes
being a-
to her perspective.
No,
in
being a
terms of her
pen
relationship.
pal and what she's gonna testify to, any more than a juror who is opposed to it. I mean, I just don't see how the fact that someone is opposed to the death penalty goes to the fact she's gonna testify the relationships she had with him through being.
But I mean, if she
That doesn't
has
mean-
relationships with 20 or 30 death row people, and
So-
she does this in an effort to enhance their chances of escaping death row, that definitely goes to her bias.
Well, I don't think there is, Tom knows, he's the one that has dealt with it, but to say that she's gonna come in here, she's an ordained Presbyterian minister, she's gonna come in here and she's gonna commit perjury in this court so she can try
Absolutely
to
not.
get someone off death.
Well, wait, don't,
But that's
they're entitled to attack her bias, and just because she is a Presbyterian minister doesn't mean that she doesn't have biases. I'm not suggesting she's going to lie, but she has biases that may color her testimony and her perceptions. So, I mean, just because she's a Presbyterian minister, it doesn't have any real, those are all points that you can bring out in terms of enhancing her credibility or minimizing her bias, but it still goes to bias, and it's still relevant. Bias is bias. And if she hates the death penalty and goes around the country befriending death row inmates in order to attempt to figure out ways to keep them off death row,
Well, it's that last
I'm not saying that it's not a redeeming quality. I'm saying, though, it definitely goes to her bias.
No, but it's the last part that is the jump.
Well, I don't know, I mean, if, I don't know why she does this. She's showing up at a bunch of different trials of people. I mean, I don't know when she befriends it. If she befriends people who are, getting a shot at retrial, or, if she participates in petitions to the court, asking for I mean, again, I'm not saying any of this is not redeeming or valuable, depending upon your perspective. There's a lot of perspectives on it, but it definitely goes to bias, and I just don't know what we're talking about. Mr. Erickson, can you give me a sense?
Your Honor, I have had a number of conversations with her. I've met with her in person. This is the first that I've heard of her possibly being involved in multiple death penalty related cases. I do know that she, reached out, I believe that she reached out to Johnny through some type of pen pal organization, and has maintained a relationship with him for, I think, going on 10 years.
Since 2009.
Yeah, and that she's been out here, I think, 4 times, paid her own money to come out and visit him, and things of that nature. I will be meeting with her tonight, and I certainly will be looking into this issue. I don't know if the state has information that she has been involved in testified in other cases in Nevada. I don't have that information.
I'm hoping to get some transcripts without telling them what the cross-examination is going to be, but it's even farther than that. Let's just say you are somebody who reaches out to capital defendants, and then you befriend them. Are you someone who is more likely to find a redeeming quality than somebody who is horrified by the actions of this person and would never befriend them? She affirmatively takes it upon herself to locate capital defendants and befriends them, and then she's going to come to a courtroom and say redeeming qualities about that particular individual. I am allowed to cross-examine on it isn't like
I'm not debating that issue. I agree with you completely. The issue is how, and I tend to, at this point in time, say that she has an interest in, helping those individuals who are death penalty eligible, rather than saying that, because at the time.
And that's fine, in '09, that's true.
You
No,
know,
he's not a capital
Yeah,
offense.
he's not a capital offense, so he's death penalty, I mean, that's not going to shock the jury. Obviously, he's death penalty eligible, because we're sitting here for the last 2 weeks doing a death penalty trial. So, I mean, I'm leaning toward, you know, you discussing with her and making sure she doesn't go to death row inmates. And I'm leaning toward, you know, making you all refer to him as death penalty eligible, and that she has an interest in that. I mean, you may ask her, don't you have an interest in helping those people who are death penalty eligible? And she says, no, this is the first guy I've ever, you know, befriended. You know, well, that, we aren't, you know, you can ask, did you befriend him because he's death penalty eligible? I mean, she says, no, I mean, I sort of piqued my interest, but because he's a great guy. I don't know what she's going to say. You know, to the degree, Mr. Erickson, you think there may be any issue, we can, you know, try to do something outside the presence of the jury.
Right.
But I'm leaning towards saying, you know, letting the state say, you know, is any of your interest in him because he was death penalty eligible?
That's fine, I mean, that would solve the problem, although it was maybe the first guy she joined that was death penalty eligible. Certainly, the court's not ruling out, there was a suggestion here that if she were to deny my question, I couldn't prove this up through extrinsic evidence, since it goes directly to the
Yeah, I mean, you
bias.
can obviously prove bias through extrinsic evidence, but I mean, let's wait until we have that issue. Be sure you've got the right, I don't know, whatever, I forget.
There's not that many of them, I believe I do. Certainly, if there's any reason for me to doubt there is, and I won't ask her the question, but I can't imagine that this happened any other way.
All
We're
right,
reaching out to Mr. Valerio.
I've seen a lot of bizarre things in my life, so you know, I'll just leave it at that. But no, I'm leaning at this point in time. I think it is relevant to bias. I'm not suggesting that indicates she's going to lie in any way or commit perjury, but it's, you know, relevant to how she may perceive or how she, you know, may describe certain aspects of her relationship with the defendant. And so I'm at this point, you know, saying, you know, let's have it, you know, to the degree that she talks about it's relevant, or she talks about her interest in those people who are on death row. Let's just leave it as those people who are death penalty eligible. I mean, even those people who are on death row are just death penalty eligible. They haven't suffered the death penalty yet. So let's just leave it at that. But Mr. Erickson, I'll leave it to you if you think you see an issue that requires further. I have the jury's here at 10. I'll ask counsel to get here by 9:30. So if there's anything you see as to this witness, we'll deal with it then.
Okay.
All right. I did get a copy from the state of the proposed jury instructions. Did you guys get that?
We got those late last night, thank you, and you know, we started going through them. We'll go through them in detail tonight and see what additional instructions, if any, or any additional ones that we want to add.
That's it.
Jury instructions.
We at least need the list of mitigators in order to complete the verdict form, and whether or not the court is going to give an instruction on mitigators or just use the statutory instruction, that's up to the court.
Okay.
And we're gonna obviously add the instruction, as an instruction, the limiting instruction.
Okay, well then, you,
That's
Whatever your limiting instruction was, they left as a jury instruction.
okay, well, all right.
That's all I'm saying.
I'll see if I can read my handwriting now 5 hours later.
Don't worry, we get Davis. You'll have it by tomorrow.
All right, but no, I do want you to decide tonight whether you oppose any of these, or want to change any of these, or we want to add these so that we can hopefully resolve those during maybe lunch hour tomorrow, right after we're completed tomorrow. In that regard, everybody seems to be anxious to leave. We want to discuss the issue in terms of whether depravity of mind includes physical abuse and defining physical abuse beyond killing.
Mr. Pesci did all that research for you. You know what my position is, the
I know what
Supreme
you're-
Court says that we're a Nevada court.
Whatever you want, tonight or tomorrow, whatever you prefer, Judge.
I mean, if you got some thoughts on it, either side, let me know so I can go take a look at it tonight and we'll finalize any arguments and the decision tomorrow.
Stuck everything in here.
No, one of them I just have electronically.
Yes. You there?
Yep, I'm here.
I didn't see you back there.
I'm actually
You're.
pondering revamping these screens here
Yeah.
because I use maybe 2 of them. And this one with jazz, I don't think I usually have once, but that's not that. Anyway, go ahead.
I would just direct you, when you go back, read Valerio versus Crawford again. And if you will go to, when I printed it, it came out as page 12 and 13.
Of the Valerio decision?
Yes,
Okay.
it would be, if you would look at the next to last paragraph above D, harmless error,
Next to last
paragraph.
paragraph
The only
above
time in my life I'll put an ultimate paragraph.
the, almost there, okay, all right.
That there, it, to me, is dispositive of the issue, because what it says is, what we just now got, Dr. Hollenberg's testimony, it said, and I'll just quote, third, the Nevada Supreme Court stated it that, as it viewed the evidence, which is the way the opinions have gone all the way through in Valerio, quote, the defendant, quote, died not from one wound, but from all the wounds combined, close quote. Now, that's going from the Supreme Court of Nevada back down to the trial. This view of the evidence is inconsistent with the court's application of the narrowed version of the instruction that it was purporting to apply, which is Robbins. As noted above, Robbins requires that there be, quote, serious and depraved physical abuse beyond the act of killing itself, close quote. Emphasis is added. Then the Ninth Circuit goes on, if as the Nevada Supreme Court believed, which is what the opinion says, and what the testimony we have here, the victim died from all the wounds combined. The wounds did not constitute abuse beyond the act of killing itself. So this case has been, that since 2002, that is what the case said. As I say, that's the next to last paragraph above the D. You know what page it is?
I can figure it out, Mr. Taro. I mean,
Well, I was just saying.
that's actually better than most citations I get where I'm having to read the whole thing.
Your Honor, if you want the case cite, because what he was quoting is how it printed out the 42 pages of his copy, but the site is 306 F 3rd at 760.
Okay.
Okay.
So,
Judge, I know Mr. Pesci can argue the instruction, but isn't that a re-argument of what we just, what has been ruled upon twice by Judge Maloney and once by you, which is, this is getting instructed.
You think like mutilation?
You always, never stop the good fight. So, I'll let you go.
Thank you, Your Honor. Pointing to Valerio v. Crawford, 306 Fed 3rd, 742. Defense counsel just wrote a portion of it. I direct you to head note 25. which is critical in understanding what we can and can't do. And that's the actual law of the case that's been talking to us about that. This is what the federal court in this circuit on this case determined. And they said under Robbins, that he just referred to a moment ago, narrowing construction, the jury should have been asked whether beyond a reasonable doubt the murder involved, quote, torture, mutilation, or other serious and depraved physical abuse beyond the act of killing itself. That's what the court's saying should have been done. That's what we're asking you to do with our instruction going on. The prosecutor could still have argued under Robbins for a finding of mutilation, as he did during the actual penalty phase trial, and for a finding of serious physical abuse. It goes on under Headnote 26. Under Robbins, the phrase beyond the act of killing itself modifies all three conditions: torture, or mutilation, or depraved physical abuse. So mutilation requires an act beyond the act of killing itself. That's what's critical. It modifies all of those things. So in order to modify depravity, you have to have that mutilation, that physical injury beyond the killing itself. That is the controlling law from the case in this particular situation. And there's our depravity of mind instruction in our proposed packet, which talks about those issues. It includes torture, mutilation, or other serious or depraved physical abuse beyond the act of killing itself. And then when you look at what Your Honor pointed us to, which is U.S. v. Sampson, which is a federal case with the Federal Death Penalty Act, but this is where you pointed us. In that particular case, there were 2 homicides. There were 2 dead people. There was actually a third, but that one wasn't taken into this federal case. There were 2 victims. One had 24 stab wounds. Another one had 15. They allowed for the depravity of mind. We have 45 to 1 victim. And then when you look at what you also pointed us to, which is the model instruction 12.07, subsection 5, it has the exact same language talking about the serious physical abuse. Our proposed instruction is in line with the authority that you pointed us to, and the authority in this case, the law of the case, which is Valerio v. Crawford. We have the right to put this forward, and we have given the appropriate instruction. And what's critical, we've been talking about Godfrey left and right when we're talking about this conversation. What Godfrey says is that you cannot leave the jury rudderless. You can't have just this, okay, depravity of mind and no explanation. Our proposed instruction does just that, provides the rudder, and gives them very specific, easy to understand explanations, including the language from this very case in the Ninth Circuit, and mirroring what you gave us from the Federal Circuit. This is the appropriate instruction that should be given, and keep in mind that in 1986, when this happened, depravity of mind was in fact an aggravator that we could utilize, and the way it read at that time was the murder involved torture, depravity of mind, or the mutilation of the victim. So we are in line with the law as interpreted locally and federally.
Let me just ask, all right, mutilation is not an issue, serious physical abuse. Beyond the act of killing, do you think that the reference to serious physical abuse is clear enough? Or is there any vagueness that should be separate? You know, with mutilation, we have a separate definition for mutilation. Is there something more that should be said in terms of defining for further serious physical abuse?
Well, I think it's when it's tied to beyond the killing itself, that is what does that. And what needs to be reiterated on, because just a moment ago they cited to what Dr. Hollander said, she indicated that only the injuries to the front of the neck, to the chest, and to the back were the lethal ones. All the rest of the injuries were non-lethal. So those are those acts to the killing, beyond killing itself. And so that would explain the mutilation. Those injuries...
No, I understand where you're going. I guess, like I said, I have no issue in terms of sufficiency of the instruction with mutilation beyond the act of killing itself. Mutilation is X, Y, and Z. The question I have is, you know, serious physical abuse. Is there something we need to say more in terms of directing the jury as to what serious physical abuse is? Or is serious physical abuse beyond the act of killing sufficient?
Can I address that? Because I think the problem with, and the concern you're having, is the ruling on you've been ordered us not to argue torture, we're not gonna argue torture. But I think that if you were to instruct on depravity of mind and say it's mutilation or other serious abuse, you're making it potentially broader than it should be. It's torture, mutilation, or other serious abuse above the act necessary for the killing. And Mr. Vaccaro, when he did his opening, did just that, right? This is, while it may not exactly fit the precise definition of mutilation, it's certainly physical abuse, serious physical abuse beyond the act of killing itself. When you defined torture as, done to inflict pain or for some other sadistic purpose, mutilation, cutting off the body part or otherwise making it imperfect, or other serious abuse sufficient. Other serious abuse is modifying and discussing, like torture, yes, mutilation, yeah, it accepts for the possibility that there is a small category that may not fit the precise definition, but is analogous to torture and mutilation. So by taking out the torture definition, you somewhat suggest that there's a broader thing than is there. This is, to me, you instruct, we won't argue torture, but you instruct this is torture, this is mutilation, or other serious abuse, and you define torture, you define mutilation. Other serious abuse would be something that is similar, but not exactly torture or mutilation in my mind. That's what the instruction is, and that's what they're talking about, is in Godfrey, in all those cases beyond there, that the constitutional limiting is serious physical abuse above the act of killing itself. And torture is part of that, mutilation is part of that, and it leaves the possibility that there are some other things that are part of that. But it's not this broad thing, it's this very small thing that it is. And I think by striking the torture from the definition, you may be suggesting it's broader than it is.
So just quickly before Mr. Vaccaro goes, and I apologize, but in response to your original question, I believe where you pointed us, which is 12.07F, there is in fact kind of a drop-down explanation of serious physical abuse. And so if you want to, you could adopt that portion and maybe add it in.
Okay, let me look at that. All right, Mr. Vaccaro,
let me-
finishing up.
Right. One, the issue that we got here on goes way back when years on the notice. So this was a statutory defect that we raised way back, I didn't raise, I think Mr. Valerio or even attorneys before him raised that was granted on it. So this isn't, let's revert back, this is a statutory defect by the state. That's how we got here, and that's how we got the Bologna decision. That's one. Two, in the Valerio federal decision, which is controlling, even though I know my colleagues on the other side don't want to believe it, but the Ninth Circuit made a number of rulings on it. First, in the Valerio federal decision, they talked about what the screw-up was by the state in torture and what the screw-up was by the state in Nevada by ignoring what was done there. That's one. Two, so torture is out. Three, that when we came to this situation, quite truthfully, the old definition of depravity that they were using was part of it. And then the Ninth Circuit in the portion that I'm talking about said, okay, now let's go back to what they're claiming is they're narrowing through Robbins. And it says in that provision, quite truthfully, that you can't show, even if you apply your narrow Robbins decision, that it can't be depravity of mind because the facts of the case that have been established then, 30-odd years ago, and are still here, said it can't be. So I, for the life of me, do not know how the Ninth Circuit can say on the one that the issue of depravity of mind under the facts of this case and under the prior rulings of the Nevada Supreme Court and the Ninth Circuit decision in that section I quote, say you can't raise depravity of mind because you conceded from the get-go that over the 30-year period, or how many years it was by the time it got there, that the final of the over and above death wasn't there, citing the Nevada Supreme Court's finding, which is as well as the findings that we've had through the federal system. So it says you can't do it. Now, maybe I missed it, but when they say you can't do it and they remand the case back, it doesn't mean, yeah, we didn't really mean that. You can do it. And we cannot come 30 years later and say, oh, we're going to define away everything that was said there. Depravity of mind under Robbins was a specific thing, and the Ninth Circuit said specifically, you can't show depravity of mind under what the Nevada Supreme Court said. That's the issue.
Want to add anything?
That I did cite to that very case, I was not saying that it was inappropriate, it is that Valerio, what I read to you, which
Right.
says if we can, I'd ask you to read that, and specifically the flaw that I do take issue with the Ninth Circuit is they assume that all of the injuries caused the death. They misquote what we read in today, Dr. Hollinger's testimony, because it's not each and every injury on her body that caused her death. Some of them did. The
Well,
some
they're
that didn't.
making reference to a comment made by the Nevada Supreme Court that, that all of the injuries caused death. I'm not sure that the Nevada Supreme Court made a per se finding of fact, or whether or not that was, dicta, that was, or what context that affects it. But I mean, they weren't making reference to Dr. Hollander's report. They were making reference to something the Nevada Supreme Court said.
And in saying this, they didn't say you can't do depravity of mind. What they said is the way it was instructed was improper.
Well, no, what Mr. Pitaro is arguing is if you assume you assume that the torture, mutilation, and serious physical abuse beyond killing is a constitutional definition of depravity of mind, you can't, the Ninth Circuit is saying you can't have depravity of mind because the Nevada Supreme Court has said that all the injuries that were on her body was what killed her. So there's no act beyond the killing itself. So, I mean, that's where he's going. I guess, sort of the issue is the Nevada Supreme Court's comment, a finding of fact which, no longer can be contested in front of the jury. And so, that's.
They go on to say, if this is so, a juror could have readily concluded that none of the wounds constituted mutilation. But they're doing this in the error analysis.
Well, that's sort of how my recollection of it. But I'm going to go back and take a look at it. But I mean, that's where Mr. Pitaro is going. And I think he's referring to a comment that the Nevada Supreme Court made. Now I'm not sure. I'm going to take a look at both of them and see if I think that was a definitive finding as opposed to just a dicta comment by the Nevada Supreme Court. All right.
Yeah, and if we're going to have to rely upon, if the court's going to rely upon a finding of the Nevada Supreme Court in this case, then if you're going to rely upon that, then don't you have to rely upon their finding that there was torture? I mean, you can't have it both ways. Either we rely upon and we instruct this jury as a matter of law, this is torture, or we get to argue the evidence that's before the jury.
All right. Everybody, it's been a great day. Anything else I should get ready for tomorrow morning?
We'll think of something.
I'm sure you will. That's why I'm asking to come in at 9:30 as opposed to 10.
Thank you, Your Honor.
Thank you, Judge.
See you later.
Okay, Johnny?
Now should